next week?
Yeah, next week, my lord, before 5th of June or after 12th of June.
For 5th of June, Lordship, any date.
Before 5th of June. Okay. 3rd of June?
Lordship.
Pardon?
3rd of June?
Yes, my lord, 3rd of June.
Okay, Mr. H. Homo, Dr. H. Homo, learned standing counsel for NID,
National Institute of Design, NID.
National Institute of Design, submits that that he will be filing his affidavit during the course of the day, and as such has prayed for some time. Prayer is allowed. List this matter. Mr.
Lordship,
Wait, just a second. And N.K. Sharma appears for the petitioner. List this matter on 3/6/2026.
Interim order is operating, Lordship, that may be continued. Lordship.
Interim order passed earlier shall continue until the next renewable date.
No problem. I'm deeply obliged, Lordship.
Yeah, please, Lordship. I beg to mention item number 54, though the other side has not given the consent. Lordship, there is a case in IA, we have been directed by this honorable court to file affidavit in opposition. The affidavit in opposition has been sent from Odisha. My lord, it will be received by tomorrow or day after tomorrow. My lord. Without that pleadings, my lord, I think it is not possible to take up the matter. Lordship, may I pray that this matter be taken up next week? But others, I make it clear, others had not given the consent for the same.
You are for the respondent?
I am for the respondent.
This matter,
In the
Lordship,
irate. Yeah, yes, you are there.
Lordship, this matter, Lordship, Senior Counsel Mr. H.K. Das is appearing, Lordship. And we have some urgency, Lordship, may kindly, Lordship, may adjourn this matter in the mention or Lordship. Lordship, let the matter reach.
Let the matter reach, then this
My
is
lord,
very
my
fine.
general will be
Make
there.
submission in the IA, Lordship. They are going to start their class, Lordship. There is some urgency, Lordship. We want to. press
Some
the IA.
urgency, let the matter reach.
Lordship, no problem, because since consent is not there, therefore may not. Lordship, my
Consent
junior will be
clear.
there. My junior will be there at the time of.
It's
But
okay.
Lordship, pleadings are necessary because they have made certain allegations which we have to
Lordship,
controvert.
get it.
Let me.
It's okay.
Now-
Let your junior be
Yes,
there, I'll
yes,
consider.
my lord, that affidavit has already been sent from Odisha, but tomorrow, day after tomorrow, I will file and immediately I will file it out.
Yes.
Pleadings are necessary, madam. Without pleading, I think possible.
Yeah, I'll consider that.
Fine.
Only
Item
let him come, Mr. H.K.
Absolutely,
Das's
madam.
day.
54.
Deep level.
Please. I think mention item number 41 is Lordship order. I am
41.
41 is Lordship.
Yes.
Lordship, I have filed additional affidavit in this relates to the writ petition in Lordship, and it has not been taken up. So the matter may be adjourned for the day and any other day come up.
Why has it come up for orders? Perhaps for these affidavits part?
No. Last occasion, we did not approach to file affidavit. Today, in the meantime,
Let us see why it is, or if, of course, if it reaches. But, okay, you want to file affidavit in
yes,
opposition
I
to-
have already filed. It has not been tagged to the
that. Okay, Miss, you are for the respondent.
petitioner, Lordship.
So you have filed what?
Additional
Additional,
affidavit.
additional.
Yes, subsequent development is there, so
Heard Mr.
as to say.
S. Hussain, learned counsel for the petitioner, who submits that he has filed an affidavit, he has filed an additional affidavit, which is not tagged with the records, and as such has prayed for some time. Prayer is allowed. Registry to do the needful
Lordship.
and bring the said affidavit in record. List this matter on
29 May,
29th of May.
Lordship.
May I please, Lordship? I beg to mention item number 14 for admission, Lordship.
14.
Yes, Lordship.
What?
Pass over for the day, Lordship. I am appearing on behalf of B. Buragan.
21 matter. Number of years have elapsed.
Actually, Lordship, I am appearing on behalf of B. Buragan, Lordship. He instruct me, Lordship.
Achha, you are for the petitioner on
Yes,
behalf
Lord.
of. But then 21 matter, admission. I don't know why it has come up. What is the matter about? Okay, a short date, huh? Mr.
P.K. Gogoi, Lordship.
P.K. Gogoi, appearing, learned counsel appearing on behalf of
B. Buragan, Lordship.
B. Buragohai submits that the instant matter be taken up on a later date. Prayer is allowed. Prayer is a full stop. Since the matter relates to the year 2021 and numbers of years have elapsed, a short accommodation is granted. And as such, the list matter may be listed on 5th of June.
I leave it.
Lordship, I beg to mention item number 19 for adjournment.
19.
19, Lordship. The engaged counsel due to some personal difficulty will not be able to appear, Lordship. And we have the consent of the other side as well.
Okay.
Can it be listed after a week?
After
A week, next week.
week, Mr.
MP Chaudhary, on behalf of NSIK, MP Chaudhary.
You are also MK Chaudhary.
Yes.
Mr. MK Chaudhary on behalf
MP, Your Lordship, not
MP. Okay, heard Mr. MP Chaudhary, learned counsel on behalf of Mr. MK Chaudhary, senior advocate, senior counsel, for the petitioner. Mr. Chaudhary submits that the conducting counsel has some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter on 8th of June.
Release the matter on the 22nd of June.
Acha, you are there in this matter?
For the respondent number 3 and 4.
In this item 19? When do you want?
22nd of June.
It's long time, is it?
While unless senior counsel will be out of station for this.
You are for private respondents.
Okay.
You are for private respondents.
No, respondent 3 and
Respond number 3 and 4.
on behalf of PD Nair.
Okay. Acha, then suggest on a early date because 22nd is too long.
15th of June.
15th of June. 15th of June, good.
May I please, your lordship? I beg to mention item number 22, lordship. We have taken consent from the other side, lordship. Lordship, our affidavit is ready, but we are yet to receive the signature.
You are for the respondent?
Yes, lordship.
Okay,
lordship.
Miss
B. Bora.
Lordship,
P.
and
Bora.
I'm for the petitioner in item number 22. My only humble submission here is that a short date will be fixed.
Acha. After 1 week,
Yes, Lordship.
Miss
B. Bora.
B. Bora, learned counsel for the respondent. Number?
BTC, lordship.
Or learned counsel for the BTC submits that an affidavit on behalf of the BTC is made ready,
Yes, lordship.
but she requires some time to file the same. Miss
Lordship.
P. Bora, learned counsel for the petitioner, however submits that a short date may be granted. As such, list this matter on 4th of June, Thursday.
Yes, Lordship.
Yes, Mr.
Item number 13, Lordship, kindly adjourn for today.
Item number 30.
1-3.
1-3. Okay. Yes, Likha, Mr. M. Alamge, learned counsel for the petitioner submits. This is also 21 matter. I'll give you a short date, huh?
File is not available in the chamber. Party contact with me for a long time, Lordship. Kindly.
1 week's time, huh? You can reconstruct the file somehow.
No interim there.
Huh?
No interim.
No interim, but then 2021 matter,
Lordship,
no? Mr. Alamge, learned counsel for the petitioner submits that that he has some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. However, seeing the matter of 2021, a short accommodation is granted. Accordingly, list the matter on 2nd of June.
2nd of June.
Mm.
Lordship.
May I please mention item number 23 and 24, my lord.
23 and 24.
25. I am for the petition.
23 and 24.
24, my lord.
They are analogous matter.
My lords.
Yes. Huh.
And
What
I can
happened?
think Mr. PK said he has some difficulty, my lord, today. And let's take up the matter 2nd week of June, my lord.
Okay. Mr. Huck, right?
AK.
AK Azad. No, what's your name?
AK Azad.
AK Azad. There's another AK Azad also, no?
Yes, yes.
Mr. AK Azad, learned counsel for the petitioner submits that there is some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter on 10th of June.
Can it be 9?
Second week of June. 9th of June.
9.
9th of June.
Always.
May I please proceed? Lordship, I beg to mention item 55.
55.
Yes, Lordship. Supplementary order, Lordship.
Huh.
Senior counsel AK Tutor is supposed to appear in this matter, Lordship. He's supplying from keyboards.
Oh, okay. Learned counsel appearing for, yes, Mr.
My name is Sharma.
S. Sharma. Mr. S. Sharma, learned counsel for the petitioner submits that Mr. A.K. Purkaster has medical issues and as such has prayed for some time. Prayer is allowed. List this matter when?
So,
After?
after a week,
List this matter on 11th of June.
August.
May it read. I am paying for listing of a matter Friday, Lordship. Friday, another series of matter was listed, Lordship. Similar matter, Lordship. That
Okay.
of life.
Paying for listing, Lordship.
You can give it to the court master. Court master. Yes.
May it please your lordship.
You're there for what? Mr. Bharadwaj.
Item 1, my lord.
Hmm.
My lord, this is regarding non-deposit of the NPS contribution of the petitioner who is serving as an assistant professor in a university. My lord, what happens is from my salary, 10% is deposited in the NPS account, and from my employer, 10%. So my prayer is, what I have noticed in the year 2022 is that from September 2017 onwards till 31st of July 2020, although that particular deduction was done from my salary, in my account it has not been deposited. So at this moment, my lord, this is an amended writ petition. There was a mistake and I amended the writ petition. So it's of 2025. My lord, I'm seeking for a notice, my lord. Let the respondents respond.
Who is appearing for the respondents? Anybody? Acha, you are there. So 10% has been deducted from his salary.
We are for
Uh-huh.
I'm for AC, madam.
Huh.
Different concern will give reply.
Acha, so who is appearing for it? Finance, Mr. Talukdar can appear. And pension, Mr. Saikia. Director of Higher Education. Yes. Again, pension, again, accounts, treasury officer, accountant general. So,
Or name not showing.
your, yes, I think, right, it is shown. GSM, SC, accountant general,
Education is from.
SK Medhi, okay, he is there, and finance. Secondary education, higher education, you are for higher education.
Hello, ma'am.
So you are there for three, only three. Mr. Likha, Mr. P. Bharadwaj, Learned Counsel for the petitioner. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for a direction to the respondent authorities to deposit the National Pension System contribution of the petitioner and his employer for the period starting from the month of September 2017 to 31/7/2020 in the account of the petitioner bearing number 1101 450 48859 along with interest as specified in the office memorandum of the central government dated 12/4/2019. The Learned Counsel for the petitioner states that 10% from the salary of the petitioner was deducted, but the same was not deposited in his account. Full stop. Issue notice, returnable by 3 weeks. Mr. P. Saikia appears for respondent number 1, 1, 4, 1 and 4.
As my lord.
As Mr. S. Das appears for respondent number 3.
Madam.
Mr. S.K. Medhi appears for respondent number
Sir, 7.
only 7. Accountant General. Treasury Officer,
Finance will appear.
Mr. R.K. Talukdar. Tell him, huh? He appears for respondent number 2, 6, right? Treasury Officer and Finance.
Finance, H. Alia.
R.K. Talukdar doesn't appear.
No, RK
Lordship, I can appear for the Treasury Officer.
Yes, Mr. P. Nayak,
P. Naik, yeah,
Learned Counsel appears for
on
respondent
behalf
number
of the Finance Department.
and also 1 and also the 2 finance.
I'm sorry, my lord, I am not having the copy of the writ petition. If Treasury Officer is there, I am there. If Finance Department is there, I am there.
Okay, 2 and 6.
All right.
Treasury
Five.
officer of Pathar Gandhi sub-treasury, you will appear. Sri
Oh,
Bhumi.
yes, Treasury Officer, it's Finance Department.
My lord,
So
and,
2
and five also, my lord, the Director of Accounts and Treasuries. Five
Yes,
also,
it is
Mr.
yes, Finance Department.
okay, 5. So 2, 5 and 6.
Yes, ma'am.
2, 5 and 6. So 8, 9 and 10, you'll have to take steps.
My lord, I have to take steps, my
The petitioner is directed to take steps for service of notice upon respondent number 8, 9 and 10 by speed post with AD or by usual process. These are covered. List this matter on 18th of June or 19th of June.
Any
19th
day.
of June,
My
Mr. Bharadwaj, 19th of June.
SC higher education may be shown in the cause dispatch.
Acha. The registry is further directed to show the what nomenclature,
Yes, madam.
to show the
SC
nomenclature of nomenclature, that is SC
higher education.
higher education. A nomenclature
Not
of the
selected,
party,
Party.
that is SC higher education.
Obliged.
There is an IA also, Mr. Bharadwaj? No.
My lord, that has been disposed of because the writ petition has been amended, my lord. I have filed the amended writ petition also.
Okay.
Obliged.
Yes, item 2, Mr. Islam, yes.
This case, your lordship, I filed this petition.
This is for admission or orders
Order.
or motion.
Motion.
Acha, what additional affidavit has been filed on behalf of additional? What about counters by the other party?
My lord, in this matter, I am appearing for SSA. This is respondent number 2.
Mm.
I have already received instruction. Instruction dated, it is in the month of March itself, we receive instruction. If lordship comes to the prayer portion, the prayer is basically for directing to the respondent to construct the upgraded school building. And the report I have received, lordship, as per the report from the circle officer, the construction has already started. The construction is going at the land donated by the, local people, and the progress is up to post plate level, lordship. I don't know what is post plate level, but it is an instruction of March 2026, lordship.
So otherwise construction is on.
Yes, it has
On the
already
land
started.
and on the land given by the public. That is what you want?
Yes, that is the prayer itself.
Public meeting, SMC and school managing committee, it is selected one place. For construction, other person, they are selecting the another place, constructing.
So you are not happy with that?
That is the case.
Or they are not happy with the place of construction?
This is the case here. And
But it has already started at a place.
photograph.
And the report says it is started at a place. The place where foundation stone was laid was selected in a public meeting.
So it was selected in a public meeting. Foundation stone was also
In,
laid.
in presence of two numbers of Gauhati President 81 and 84 GP. And it's a place, the work was started accordingly, and at present progress is up to post plate level. So the progress is there. And the prayer, if lordship comes to the prayer, there, they are praying for initiation of construction, if my understanding is correct,
Yes, to construct the upgraded school
to
building.
construct the upgraded school building.
What is upgraded school building?
Earlier, there is a.
It was
Oh, acha. To construct the upgraded school building of so-and-so on the land donated by the local people and selected by SMC as well as local public in general meeting dated. You are talking of this meeting, Mr. Nayak,
Yes,
27,
Lord.
12, 25.
It's a
27, 12, 25. What other meeting
yes.
it can be? Same
And
meeting?
it appears from the report, lordship, foundation stone was laid by the local MLA, lordship, on 29/12/2025.
Yeah, exactly after that meeting.
2 days later.
Yes.
So same meeting perhaps,
Same meeting. Meeting is
not a same meeting.
They have constructed 70. I have annexed the photograph.
Mm.
Little evidence, I have annexed the photograph. It will not stay order.
So what you are disputing is the place.
Place is that public,
The photo, dismiss over the
but they are constructing another place.
Public had decided at one place and they are constructing another place.
To GP president and the contractor, they are constructing another place. 1.5 kilometer distance.
That is your grievance. Is it nearby?
Half kilometer.
1.5 kilometer.
Same revenue place. Additional evidence I have.
You are aggrieved to such an extent, only 1.5 kilometer away the school is being constructed.
There is main place here. We have selected in Bangladesh, it is 8 bigha of land. Both the land are government land. That's why due to not stay order, they have already constructed. I have a photograph. This 70.
So, Mr. Nayak, what they are saying is that they don't want in that place where the
In that situation, Lordship will allow me to have the updated instruction and file one affidavit. In that situation, they will be able to counter.
let him get the otherwise the instructions that you have put, he knows, he said.
Yes,
But
already
then he
started.
wants it in a different place. This GP president and all, they have decided and constructed in one place which they are not agreeable. Okay, you file an affidavit. Let
Lordship.
Mr. Yes, shortly. Heard Mr. S. Islam, learned counsel for the petitioner, and Mr. P. Nayak, learned counsel for respondent number.
I am appearing for respondent number 2.
Respondent number 2. As a mission director, Samagra Shiksha Assam. What about others?
Others I'm appearing, but it is a Samagra Shiksha, they have the main role to play.
Achha.
So secretary, director, and the respondent number 5, I'm appearing. 1, 3, and 5.
SMT History, learned counsel appears for respondent number 1, 3, and 5.
3 and 5.
1, 3, and 5.
Yes, yes.
And Mr. P. Saikia, learned counsel. No, 7 is not there.
5. 1, 3, and 5.
No, you are 1, 3, and 5. Mr.
Yes.
P. Saikia?
So he is for 4. The deputy commissioner.
For 4. And 6, who is appearing? Service is complete.
No, it's notice not issued.
Hmm?
This case notice was not issued.
Achha,
Director obtained
okay.
instruction.
Hmm?
Director was obtained instruction earlier.
And so. Mr. P. Nayak, learned counsel for SSA, submits that he has an instructions provided to him during the month of March 2026. And according to the said instruction, he submits that the construction of the upgraded school building of Dharmapur Dhulauri DHU-LAURI Secondary School. Construction, the construction of the upgraded school is going on the land, on the plot of land donated by these local people. And the foundation stone, and that the foundation stone was laid in presence of 2 Gau Panchayat president. However, Mr. S. Islam submits that the construction of the said upgraded school is being carried on in another plot of land, and not the plot of land for which a meeting was held by the local public and decided thereupon. He further submits that the plot of land on which the construction is going on কি বুলি ক'লো প্ৰথম পৰা পঢ়াচোন লাইনটো ফাৰ্ষ্ট লাইন নহয় ছেকেণ্ড থাৰ্ড which a meeting full stop. Mr. P. Nayak, learned counsel for the SSA, therefore submits that he will get the updated instructions and would file an affidavit incorporating the same. and as such has prayed for some time. Prayer is allowed. List this matter on
Next week, otherwise building will constantly.
on 1st of June. Mr. By
May I please, Lord, let this matter come after vacation because in the meantime, it states 46% has already, achieved progress.
46% of the work is
Yes,
over.
yes. It states indicates physical progress has reached 46%.
46%.
It's a short date.
But not after vacation. That will be too long. File it by 17th of June.
Yes, 17th of June is possible, madam. Yes, I'll file it, madam.
Is
Short
this,
date because only instruction, because otherwise building will be complete.
he wants a date earlier to that. 10th of June?
Others March, they have time.
10th of June will be too early, but I will try, my lord. Let me try.
Okay, let him try 10th of June. List this matter on 10th of June.
Oblige, madam.
Yes. Item 3. So additional affidavit is filed. So what happened? Erica nuts were seized
Lordship.
in Badarpur.
My lord,
Buyer and seller are somewhere
my
else.
lord, kindly see the additional affidavit, kindly see the affidavit. Additional affidavit.
Acha, so what is this? This is writ petition.
Lordship.
So what happened? What is your additional affidavit about?
Additional affidavit on landed honorable justice Devashish Bodo while hearing the matter passed the order to the effect while kindly go through the order of justice Bodo.
No, orders are here. There's only one
In
order.
order to
Only one.
in order to my lord, clear the confusion, my lord, I have submitted the additional affidavit to the effect that additional affidavit, my lord.
Acha, what have you prayed
we
for?
cannot release of the goods.
Release of the betel nuts.
Betel nut, my lord. I have covered by various judgment of this court, Patna High Court. I have submitted a written argument on the next on 4th of May, my lord, and I have submitted my landed friends the written arguments along with my lord, 5 judgments, my lord.
Acha, wait, there's such a long prayer commanding the customs authorities to act in accordance with law, directing the concerned responsible authorities show cause as to why the illegal, unlawful, arbitrary collected from domestic transaction. You have questioned a seizure, right?
They have also filed one application for provisional release before the department. That has been rejected, Lordship. They have challenged this also in.
That was refused on the confusion came in the mind of the additional commissioner that reasonable belief, it may be smuggled.
Lordship, it is at the motion still, let notice be issued. I will file my affidavit, Lordship.
My lord, the betel nut, my lord, as experience, it will be perished, my lord. My lord,
When was it seized?
seized on, my lord, 30th 11/2025.
11/20/25.
En route, on en route, my lord. It was purchased from in, my lord. It was the land was it was loaded in Hailakandi.
Acha, you are appearing for customs.
Lordship.
And my lord, the land was intercepted in between en route, my lord. It is coming to the godown.
Acha, it was supposed to be from where to where?
My lord, from Hailakandi to, my lord, the petitioners go down at Nagaon,
Acha.
Rupai.
Rupoi Hat. And it was seized in Badarpur.
Badur. 30 kilometers, my lord, distance
From?
from
Hailakandi.
Hailakandi, Badarpur. And it was.
Okay, let them file an affidavit. That opportunity has to be given. Because what they are saying is these are smuggled goods.
Lordship, foreign origin.
According to them, my lord, no testing, nothing else was covered by. My lord, kindly see the judgments.
Okay, we will see the judgment. Let them file an affidavit.
Lordship.
We'll give you a short date.
2 weeks, Lordship.
My lord, kindly.
2 weeks.
My
2
lord,
weeks
kindly
is reasonable enough.
give them 1 week, my lord.
Lordship, 1 week won't be enough, Lordship. So it is.
Heard, Mr.
Abdul Hamid.
A. Hamid, learned counsel for the petitioner. By this application, the petitioner has prayed for release of the areca nuts seized by the custom authorities on 30/11/2025.
My lord. My lord, kindly record, I have submitted it.
The petitioners, the learned counsel for the petitioner submits that the said areca nuts were dispatched from Hailakandi on being sold to
But it was loaded on the truck from Halakandi. It will come to, my lord, Rupai.
and to
And en route, it was intercepted on en.
Acha, it was by way of sale to the buyer at Rupohi Hut
Rupai.
in the district of Nagaon. However, he submits that the said areca nuts
It
were
is not
seized,
Indian origin, my lord. It is not Indian origin.
were seized in Badarpur, that is 30 kilometers away from Hailakandi. Issue notice, returnable by 2 weeks.
My lord, I like it's short.
2 weeks. Otherwise, I make it 3 weeks. 2 weeks. Mr.
K. Jain, Lordship.
Wait, who are the parties here?
All the customs.
You are appealing for all the
Yes,
respondents?
Yes, Lordship.
Okay. Mr.
K. Jain, Lordship.
K. Jain, learned counsel appears for all the respondents. Extra copies be furnished to the learned counsel by the counsel of for the petitioner within a day or within 2 days from today. List this matter on 8th of June.
But I
Next
have
to
given
next
the
Monday.
Actual evidence copy, I have already given.
No, extra copies of the writ petition. Because he is for so many, right? So he has to give and get their response.
My lord, my junior.
Okay, yes, she will give. I said petitioner, counsel for the, list this matter on 8th of June.
Lordship.
My lord, kindly.
Next
make
to
it-
next Monday.
My lord, kindly make it 5th June, my lord, Friday.
Fifth will be.
5th June, my lord, I am begging you lordship pardon.
You try, 5th of
I'll
June.
I'll try, I'll try.
5th.
5th of June, 2026.
My lord, may I say one thing? Kindly make it pardon.
No, not to partner. No. I've not even gone into the facts. What areca nuts and all foreign areca nuts. Let's see.
Much obliged, Lordship.
My lord, 5th of June.
Yes. Yes, 4. Yes, Mr. Rahman. Today it has come up for the first time, it seems.
Well, in the meantime, I file a reply.
Yes.
Well, kindly reports.
Reply means
Reply of the.
you expect him to file within this week so that you can file a reply. Let his affidavit come, then you file. In the meantime, the learned counsel. In the meantime, then not required. Let us see what he writes.
Maybe the petitioner left out might not be subsequently might not be scanning committee.
And petitioner is what?
They are working as a college.
Working as
Assistant professor my lord in Venture College my lord.
assistant professor in venture colleges.
But
Okay.
subsequently my lord, they are a screening committee might say that they are eligible for tutor my lord. And accordingly my lord, they are a direct.
I think the concept is changed. Assistant professors are tutors.
Tutor. Considering their eligibility my lord, some are appointed as tutor or assistant professor my lord. Those who are completed set or PhD my lord, they are considered appointment. They are considered.
Sir, Mike to Tickerson, I'm not able to hear you properly. What?
Actually, my lord, their service may be provincialized
What you said is that they were appointed as assistant professors
by the managing committee, my lord.
by the managing committee of the
And-
college.
But they are left out, my lord, when the college was provincialized, my lord.
Huh.
But subsequently, my lord, the state screening committee verified there are 96 person and their qualification, my lord, and they found that they are eligible for tutor or assistant professor, my lord. And thereafter, my lord, Director of Higher Education, White letter dated 18/3, made a proposal for creation of 116 number of cadre posts for provincial, my lord.
And but till today, the state responder has not taken any action, madam. And connected matter, madam, he.
Okay, you file your counter. I'll issue notice today. Okay. Heard Mr. H. Rahman, learned counsel
S.
for the,
Rahman.
uh-huh,
S. Rahman.
S. Rahman, learned counsel for the petitioner. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for what? Provincialization of his services. Has prayed for provincialization of his services as assistant teacher or tutor.
As tutor or assistant professor. Madam.
As tutor or assistant professor. Full stop. The petitioner has also prayed for a direction to the respondent authorities to give them there is only one or six professors to give them consequential benefits like arrear pay and allowances with effect from 18/8/2021. The counsel for the petitioner submits that the respondent authorities had provincialized the services of similarly situated assistant professors. However, the present petitioners were left out of consideration. What is the reason?
My lord, their, as per their, my lord, their master degree has been not been verified, my lord.
In fact, on the alleged reason that their documents were not verified. Issue notice, returnable by 3 weeks. Mr. S. Das, learned counsel appears for respond number.
All the respondents, madam, 1 and 2.
All the respondents.
Madam.
For all the respondents, extra copies may be served upon the learned counsel for respondents in a period of 2 days from today. Place this matter on.
Connecting matter, my lord, 20 WBC no 2076, my lord.
It is what? Filed or it is listed?
File, my lord.
Let it be listed. We will then tag it.
Already listed, my lord. Already notice has been issued on that matter, my lord.
So they say that the learned counsel for the petitioner further submits that there is an analogous matter, which is
WBC
petition number
2076.
2076 of 2026. And prayer is made to take up both the matters together. Prayer is allowed. List both the matter on 18th of June 2026.
This present deed petition was filed by petitioner by challenging, excluding the petitioner from document verification process, Lordship.
For provincialization? What?
No, Lordship, as appointment of teacher, Lordship.
Oh,
assistant
appointment.
teacher.
What happened? What is the prayer here?
Lordship, prayer is, Lordship,
There is an impugned notice by what?
Lordship, impugned notice, Lordship,
To direct.
placed by respondent number 3, Lordship, have asked for UDI's code, Lordship. As one.
Oh, Dias code.
Yes, Lordship.
So what happened? He didn't, he was directed to submit his Dias code. Then?
Yes, yes, Lordship. Similar matter is pending, Lordship, before this honorable court. Maybe this matter may be list with others matter.
Let notices be issued.
Yes, Lordship.
Heard Mr.
Yes, Hussein.
S. Hussain, learned counsel for petitioner. By this application, the petitioner has prayed for setting aside and quashing of the impugned notice dated 19/11/2025
And 17/11.
and as well as 27/11/2025. Where is annexure 7? Where is annexure 7? This one. Where is annexure 7? Where is that impugned order?
Page number 74.
74.
Yes,
But it's annexure 8, it's written, what happened? Oh, acha, this page. 1911-2025, no. Issued by the Director of Elementary Education, Assam. So why are you offended by this?
Lordship,
You are directed to supply, give your diest code. What happened?
Lordship, when we're pursuing the DLED degree, Lordship, from NIOS, Lordship, at this moment, Lordship, and UDIS was not mandatory, Lordship. At that time, Lordship, UDIS was not mandatory, Lordship.
At that time, what is not mandatory?
UDIS code, Lordship.
Oh, diest code was not mandatory. So you did not had that code.
No, Lordship.
When you had passed your diploma in elementary education.
Lordship, yes, Lordship, 2019, Lordship.
Achha, let a senior come. Okay. So and so for setting aside and quashing Lukun Kulna.
Similar matter.
So and so by which the authorities concerned have directed the petitioners to submit their dias code. Full stop. The petitioner has also prayed for a writ in the nature of mandamus directing the respondent authorities to refrain from applying the dias code as proof in service. Full stop. The learned counsel for the petitioner submits that while appearing for the diploma in elementary education,
Yes.
the dias code was not necessary, or what you said?
Not mandatory.
Not mandatory.
It is his submission, my lord. Dice code is mandatory from 2005 itself, my lord.
Oh, it is mandatory, but then
Mandatory.
that is why I've said his
And this
submit.
issue has already dealt with by this honorable
Submission to
court, my lord.
Bhatia. Issue notice, returnable by 3 weeks. Miss S. Chutia, learned standing counsel appears for respondent number
My lord, 1,
1,
2, 3, 1, 2, and 3, my lord.
1, 2, and 3. And NCT, you are for number 4 and 5.
No, only 4.
Only 4. Mr. I. Alam, learned standing counsel appears for for respondent number 4.
My lord, may record our submission, my lord. This issue has already been dealt with by this honorable court, my lord. That petition was dismissed, my lord. And again, they have approached the honorable division bench, my lord, by way of writ appeal 345 2026, my lord.
Then?
That was also, my lord, to some direction was issued, my lord, but that will not affect, my lord, give any right to the petitioner also, my lord. So that maintainable part may kept open, my lord. Because this petition is not maintainable, my lord.
This advertisement said this was different, Lordship. This was
Maybe different, my lord, regarding, my lord, dice code, my lord, this honorable court has already dealt with that.
similar.
that too, my lord.
Read was pending, Lordship.
Read was pending, my lord.
Okay, we will
My-
consider
my-
on that.
only
Let
my
his
lord
senior also
maintain-
come.
my lord-
I'm unable to understand what he says.
My lord.
Okay.
Only, my lord, maintainability part of this petition,
Yes.
that may kept.
Miss Chutia, learned standing counsel for the elementary education, however, submits that the maintainability of the instant writ petition be kept open. Or it can be decided today itself, but then Mr. You are led by A.T. Sarkar.
Yes, Lordship.
He is not there today. Okay, then we'll take, instead of issuing notice, we will take it up on a next date. Let Mr. Sarkar come.
Lordship, would another
If it can be
matter-
disposed of in the motion
Others
stage
matters are
itself.
also pending, my lord, like similar, my lord. That let notice go, my lord, we'll file our affidavit.
Acha, okay. Submits that the maintainability of the instant case be left open for consideration on the next date. Prayer is allowed. List this matter on 16th of June, 2026. Okay, on the next day, we will see about it. And if you want to file affidavit, you can.
My lord.
Hello.
6, no one appears. Okay, we call after some time. Both the methods are on, so maybe somebody is not been able to get the internet. Item 7. Yes, Mr. Laskar?
Tutors.
Mm-hmm.
We were tutors, my lordship.
You are tutors.
Tutors.
Yes.
Our original appointments were assistant teachers,
Mm.
so which were subsequently considered as irregular. So government of Assam took a policy decision, and pursuant to that policy decision, we have been accommodated. Our grievance,
Raise your voice or there's problem with the mic. Yes. Yes.
our grievance is that, my lordship, as we have a DLAD diploma, they're entitled to be accommodated as assistant teacher. So we filed representation that we have having diploma, and we have relied also on a particular judgment which I have annexed my sheet. Kindly see the judgment.
It's okay, but today is the first day. Let notice go.
Yes.
Yes, Mr. Chair.
Lordship, I'm appearing. Lordship, in this matter, I'm
For
appearing.
elementary.
Yes, Your Lordship.
Okay, so Mr. Fukan appears. Any one of you can appear. Okay,
My
heard
lord.
Mr. S. Loskar,
SB.
heard Mr. S.B. Loskar. SB, right?
Yes.
SB Loskar, learned counsel for the petitioner. By this application, the petitioner has prayed for a writ of mandamus directing the respondent authorities, more particularly respondent number 1 and 3, to consider the claim of the petitioner for grant of pay scale at par with assistant teachers of LP, UP schools and as well as for consequential upgradation from the post of tutor to supernumerary post of assistant teacher. I think somebody has to put off the mic. To supernumerary assistant teacher on the consideration that petitioners had acquired diploma in elementary education prior to their joining. Full stop. Issue notice. Mr. A. Fukan, learned standing counsel, appears for respondent number
1, 3, 4, and my lord, 5 and 6, 5, 6, and 7, my lord.
5, 6, and 7. Huh?
My lord. 2 is finance.
And Mr. Who can appear for finance? Mr. R.K. Talukdar or S. Das? Mr.
My
Das,
lord-
you can appear for finance? No.
My lord, Mr. A. Chaliha, my lord.
A. Chali.
A. Chaliha.
A. Chaliha, yes. Mr. A. Chaliha appears for respondent number 2. Extra copies be furnished to the parties within a day from today, within 2 days from today. List this matter on 16th of June.
Deeply obliged, my lord.
Yes.
Lordship, the grievance of the petitioners is that, Lordship, they were all accommodated as tutors instead of teachers, Lordship.
Tutors, not as teachers.
Not as teachers, tutors, Lordship, by a series of orders. Lordship, we are actually praying for similar order, Lordship. Similar order has already been passed in two cases earlier, Lordship. Lordship, proposal for upgradation of their service has already been sent, Lordship, and back-end verification has already been done. And that all the documents I have annexed here with Lordship. At this stage, notice may go, Lordship.
Heard Mr.
P.
P. Khatoniya, learned counsel for the petitioner. By this application, the petitioner has prayed for quashing and setting aside of orders dated 30/1/2021, issued by the Director of Elementary Education, Assam, by which the petitioners were accommodated as tutors in different schools of Nagaon district. The petition, it is the case of the petitioner that they should be accommodated as teachers as they had the qualifications for the same. Issue notice, returnable by 3 weeks.
I'm appearing for respond number 1, 2, and 3, my lord.
Yes. Mr. Kaushik, B.
My lord.
Kaushik, learned counsel appears for respondent number 1, 2, and 3. All respondents.
All
All
respondents.
respondents. Extra copies be furnished to the learned counsel appearing for the respondents within a period of 2 days from today. List this matter on 18th of June.
Grateful, my lord.
Item 9.
Yes.
In this case, my lord, initially the petitioner was appointed, enrolled in the Assam Rifles in the year 2001.
Enroll in the?
Assam Rifles, my lord, as a rifleman.
Cannot get you. What?
Initially, my lord, the petitioner was enrolled in Assam Rifles as
Assam Rifles.
Assam Rifles as rifleman, my lord, but his service was terminated, my lord, on medical ground, my lord. Thereafter, he approached this honorable court, and this honorable direct the respondents to, my lord, conduct a fresh, my lord, review medical board and to examine the petitioner, my lord. Again, the petitioner was examined, my lord. He was subsequently, my lord, he was declared on, my lord, separate ground of medical ground, but separate ground on medical incapacity and arrears. Again, the petitioners approached this honorable court, my lord, and this honorable court, that order kindly see, my lord. Your lordship will find.
Okay, let H. Gupta take the notice. Okay.
My lord.
Okay. Heard Mr. H.R. Ahmed.
My lord.
Learned counsel for the petitioner. By this application, the petitioner has raised the issue that he was initially appointed as the rifleman in Assam Rifles, but was terminated later on medical grounds, for which he approached this honorable court. And this court had directed the respondent authorities to conduct the medical review of the petitioner again. And in pursuance to the same, the petitioner was again medically examined, but was again rejected on the said ground. The petitioner, however, submits on why have you challenged that?
Yes,
Why?
there was a direction, my lord. Specialist doctor should be inducted in the, my lord. Board,
Acha,
my lord.
against that, I had to hold on full stop. No. Against that, the petitioner has approached this court by filing the instant petition on the ground that the specialist was not there in the medical board when he was examined. Issue notice, returnable by 3 weeks. Mr. H. Gupta accepts notice on behalf of?
1 to 6, my lord.
Behalf of all the respondents. Extra copies be furnished to the learned counsel for the respondents. List this matter on 19th of June.
My lord. Obliged. Obliged.
Yes, Mr. Chalia.
Challenge the order by which they have been terminated from the college.
From the colleges.
They are grade 3 and grade 4 employees of the Hamidabad College, which is a provincialized college. And the principal in charge, upon receipt of an.
Okay, I'll issue notice today. Only notice will do.
Notice will do.
Heard Mr. D.P. Chalia, learned senior counsel assisted by Mr. U.P. Chaliha, learned counsel for the petitioner. By this application, the petitioner has challenged. Petitioners have challenged the orders
24/4.
or the order dated 17/4 also.
No, 74 is the direction from the government. On the basis of that, the termination order is 24/4.
Okay. Orders dated 24/4/2026, by which the services of the petitioner in grade 3 and grade 4 in the college, right?
Yes, Hamidabad College.
In Hamidabad.
Hamidabad College.
Hamidabad College has been terminated. Issue notice, returnable by 3 weeks. Mr. S. Das.
I'll be appearing for respondent number 2, SC hired.
Learned counsel appears for respondent number 2. Mr. P. Saikya, learned counsel appears for respondent number 1. One only.
No.
Governing body of Hamidabad and principal, you'll have to take notice.
I will take additional dusty service, my lord, for respondent 3, 4, and 5.
Okay. The petitioner is directed to take steps is directed to take steps for service of notice upon respondent number 3, 4, and 5 by speed post with AD as well as by dusty service. List this matter. Extra copies be furnished to the council for the petitioner, for the respondents. List this matter on 22nd of June.
My lord,
Too late.
earlier, one more case on the same point, my lord, has already been, notice has been issued, that is 2650.
Let both the matters be heard together.
Yes.
Mr. Choliha, learned senior counsel, submits that there is an analogous petition pending before this court, which is numbered as WPC number
2650.
265026 of 26, and prays that both the matters be taken up together.
Right.
Prayer is allowed. List both the matter on 10th of June,
My
on 10th of June. Yes, Mr. Rahman, you are sitting for which matter? Item 16. Okay. Not many matters. I'll finish up these. Oh, Mr. Rahman, item 16, Madhya. Item 16, yes. 16. So let the file come. Yes, you can say.
Reading has been completed, Lordship. Here, two part of the case. First part, the petitioner before your Lordship is a lecture of the Margarita College. So,
Can it be taken up today for disposal?
yes.
Achha.
Please complete.
What about the other parties? Item number 16,
Higher secondary education and the college authority, they are representing.
higher education.
Higher education.
Higher education, they can appear, and Mr. Tobildar can also appear. Or Mr. Yes. And
Forest D. Gogoi is appearing, Lordship. I'll inform him, Lordship.
for college, B. Gogoi.
D.
Bhutto Gogoi.
Dikshit Gogoi.
Oh, Dikshit Gogoi.
Dikshit Gogoi.
Is he there in the court today?
Lordship, he has asked me to inform him when the matter is about.
Acha, then
So
inform
let it come.
Let him come, he can start, he will come. Or what? After some time?
Yes, Lordship.
After some time. Get, Gita ma. Hmm.
Well, I have for implement of parties, my lord. New respondent, my lord. So, my lord, may allow the I am for implement.
They are required? They are required.
They are the new incumbent, my lord.
Oh, new incumbents. The earlier ones have retired.
Either retire, my lord. Or
Okay. Heard Mr. P.J. Saikia, learned counsel for the petitioner, for the applicant. By this application, the applicant has prayed for implement of the new incumbents who have joined in the post of
all the 1 to and 1 to 4 minutes.
post of which, this one, right? Petitioner.
All the 4 respondents.
Who are the earlier ones?
Early one, my lord, in the cost settlement.
The cost titles are confusing.
One, Pritam Soikia. The earlier one with Pritam Soikia.
Acha, earlier one was Pritam Saikia, Otul Bora, Rita Sharma, and Shyam.
Yes.
Right.
New,
They have retired. All the 4 have retired.
yes, either retire or transferred.
Acha. New incumbent, kya bola? I have joined in the post of Commissioner, Government of Assam Higher Education. As respondent number, Mr. Narayan Kumar. Mr. Narayan Kumar, who have joined in the post of Commissioner, Government of Assam Higher Education as respondent number 5.
Yes.
As respondent number 5, comma, Shri Dhubajyoti Bora, the Director of Technical Education Assam, as respondent number 6. But you have not written that way. Mr. Rupam Borua, Principal Jorhat Engineering College, as respondent number 7, and Mr. Joyantok Narlikar, the Commissioner and Secretary to the Government of Assam Finance Department, as respondent number 8. The full stop. The learned counsel for the applicant submits that all the other four respondents, that is respondent number 1 to 4, have retired or transferred. As such, the impleading application is allowed. The petitioner to amend the cost title, to file the amended cost title amending the same in the contempt petition, being contempt case number 347 of 2020. This IA is disposed of.
Notice may be issued.
Let the cause title be amended or after that notice disposed.
Obliged.
48. Yes, Mr. Mondal?
Yes, may I please? My lord, gist of the case is, my lord, the petitioner has been recommended by the District Scrutiny Committee in the year 2019. Thereafter, my lord,
For? Recommended for?
For provincialization as assistant professor. Now, my lord, she has, my lord, acquired the, my lord, requisite qualification. So he is recommended for a tutor principal.
Achha.
In his setup.
Now, what happened to the earlier recommendation?
Now, my lord, subsequently, my lord, in the year 2013, he is also recommended by the state level scrutiny committee. And since 2013, matter is pending. Now, subsequently, my lord, the respondent authorities, my lord, issued an, my lord, instruction by which, my lord, the contractual and, my lord, casual workers are sought to be discontinued. Now, we are apprehending, my lord, who may be discontinued. Though that instruction is not applicable to us because we are in a institution which is ventured. Those who are provincialized colleges and government colleges, in that case, my lord, that is applicable.
Achha.
Now, lordship kindly see.
Okay, let me notice be issued today.
Yes.
Okay.
Notice.
Only notice.
My lord, or my lord, may I pray, my lord, and let them bring instruction. What is the position as on date? Since 23, we are waiting, my lord.
Achha. So, Mr.
Can be
Das,
disposed of in the motion.
can you bring the instruction instead of issuing notice?
May go, my lord. Otherwise, also, my lord, I will take instruction of what is going on there, and I think they have also approached after a long time, my lord. Because
You will be in a better position to bring. So, bring the instruction. What happened to his recommendation by the SLC?
my lord,
And as for provincialization as tutor, as assistant professor. Oh no, tutor and principal.
Petitioner is, my lord, tutor principal.
Tutor principal. Okay, what happened to that? Bring the instruction if it can be disposed of. Heard Mr. M.U. Mondal, learned counsel for the petitioner, and Mr. S. Das, learned standing counsel for higher education. For higher education.
2, 3, and 4, my lord.
It's okay, only higher education. Heard the learned counsel for the petitioner submits that the petitioner was recommended for provincialization of his services as tutor, stroke principal by the state level scrutiny committee. However, he submits that the said recommendation was in the year 2023 and till date, he has not been apprised of as to what happened. In view of the fact, this court deems it fit to direct the learned counsel appearing for the higher education to bring the necessary instructions to that effect. Mr. S. Das is directed to bring the said information on the next date fixed. List this matter on 8th of June. Okay, Mr. Das, don't forget, bring the instruction
My lord.
on 8th of June, 2026, on which date Mr. Das will place the instructions.
The motion column.
Yes, list this matter again on 8th of June in the motion column.
My lord, second case is also in the same tune, my lord. Same, my lord, resolution recommendation by the state level committee in the year 2013.
13 or 23?
23. And his post is, my lord, assistant professor.
Achha. Okay, heard Mr. M.U. Mondal, learned counsel for the petitioner, and Mr. S. Das, learned standing counsel for higher education. The learned counsel for the petitioner submits that the petitioner's service were recommended for provincialization by the state level scrutiny committee in the year 2023, but till date, he has not been apprised of the outcome of the same. In view of the fact, this court directs the learned counsel appearing for the higher education to bring the necessary instructions to that effect. List this matter on 8th of June 2026, on which date the council would place the instructions. Mr. Barbia?
Yes, sir. May I please?
involved in this case, my lord. Lordship, kindly will look, this petitioner before your lordship was a, my lord, head assistant of the college.
Uh-huh.
Petitioner before your lordship is a, my lord, head assistant in a college. my lord.
What assistant?
Head assistant.
Head assistant.
Head assistant.
There is a post of head assistant. Acha. Head clerk.
After a long time, my lord. Like, and to this effect, my lord, order was also.
His service was provincialized.
Provincialized subsequently. Page, my lord, 31 is the first order. It is, my lord, total 297 posts, my lord, where, my lord, sanctions throughout Assam. And here, my lord, page 32, under clause 2, my lord, it was provided that, my lord, he should be given, my lord, NPS, new pension scheme, my lord, benefit. Then, my lord, consequential order was passed by the, my lord, field level officer, my lord, director, page 36. This is the final order of provincialization. Here also, my lord, it was reiterated the condition that I should be governed by the, my lord, new pension scheme. The second paragraph, my lord, fourth line, NPS, my lord, applicable to the petitioner. But this, my lord, order passed long back, my lord. Since then, my lord, he is, my lord, running from pillar to post, my lord, in the department, my lord. But
You wanted the old, you want the old scheme?
no, my lord, new. But for new, my lord, there should be, my lord, some deduction from my salary. And from the government side also, there should be some contribution. And after retirement, my lord, I get something, my lord. But there, my lord, no deduction from my side, from the government side, and there is no accounts is also, my lord, provided for MPF fund. So virtually, my lord, this part of the appointment order is not acted upon.
Achha.
So as this matter is matter of mandamus, my lord, at this stage, my lord, they may consider, my lord, his case, my lord, and pass necessary order, my lord.
But for this, I think notice is required because they have to see whether these the provisions are followed. Because under the NPS, as you said, some part will be deducted from your salary, some part from the government, there will be contribution. And then that will get accumulated in your account.
Yes, my lord.
So let
Not
the
my
notice.
account, my lord. There is a, my lord, independent account, my lord. After retirement, my lord, that should be
Achha.
given, my lord.
So
Let
they,
this be problem. Because finance is also
Because,
necessary.
my lord, my lord, I am praying for mandamus to consider, my lord, my lord.
let notice go today.
My lord.
Heard Mr. A.M. Barmia, learned counsel for the petitioner. By this application, the petitioner has prayed for a direction to the respondents to allow the petitioner to avail the benefits under the new pension scheme in accordance with the provisions mentioned therein. Issue notice returnable by 3 weeks. Mr. S. Das, learned counsel appears for respondent number
1 and 5, my lord.
1 and 5.
I'm for respondent number 3.
So higher education and director of higher, you of which, who is appearing for respondent number 3?
3 I am appearing. Lord.
Your name, please.
R. Boro on behalf of B. Sharma.
Mr. Boro on behalf of
B. Sharma.
B. Sharma for respondent number 3.
3.
Mr. P. Saikia appears for respondent number 4. 4. And Mr. A. Choliha appears for respondent number 2. The extra copies be given to the learned counsel for the respondents during in 2 days from today. List this matter again on 18th of June.
My lord, kindly, my lord, one internal observation, maybe the pendency of this petition may not be a bar to, my lord, consider. My lord, page 8, my lord, I have made one.
What interim?
My lord, the pendency of this, because, my lord, he will retire, my lord, the next year, my lord. So,
He
my
will
lord,
retire in the next year. So soon.
This bencher, my lord, he struggled, my lord, working since last 35 years, my lord. Only very recently, my lord, they are.
Is it required? I mean, you were allowed the NPS very recently, it seems.
Yes, my lord, because, my lord, after long fight, my lord, only.
Your
recently-
service was provincialized.
And in their order itself, my lord, it was provided that I will
Further, in the facts and circumstances of the case, it is directed that the pendency of this writ petition will not be a bar for the respondent authorities to allow the petitioner the benefits of the new pension scheme. Okay? Will not be a bar.
CA may be reflected in the constitution.
Huh?
Name of the
Okay.
in the
Name of what? GA.
CA.
Mr. Will not be a bar. Kolo. Tapos po, Mr. P. Saikya, the registry is further directed to reflect the, it cannot be named, what? Nomenclature of the GA. May reflect the government advocate Assam in the course title. May reflect government advocate as respondent in the cause title or in the cause list.
May I please? Your
Yes.
Lordship? We are students of SJ.
Students of?
Swahid
Mm.
SJM Medical College,
Mm.
Homeopathic Medical College.
Mm.
So our grievance is that, my lordship, we have passed 4th year.
Mm.
After passing the 4th year and after mark sheet has been allotted and we have started internship, all on a sudden another notification has come that we should appear in the 4th year examination again.
Because the time gap between the
Yes,
two examinations
they have
are
conducted
not.
the exam and they have not published the result on time and we are made to suffer. That is our grievance.
No, for what reason you were again made to appear in 4th exam?
That 6 months gap should be
So
there.
the 6 months gap was not there in between two examinations.
Yes.
It's not your fault, Mr. Bora. I think similar matter we have heard
Yes.
brought by Mr. M.K. Chaudhary.
Similar matter we have considered.
I am appearing for only the 1, 2, and 7.
Hmm.
The original respondent is my lord Srimanta Sankadev University, my lord.
Acha.
Their names are also not shown in the cause. My lord, Mr. B. Gogoi is appearing, my lord.
Yes, Mr. Gogoi.
My lord.
We have heard similar cases, you remember?
Yes. In fact, my lord, in that case, lordship has given the relief.
No, interim.
Interim relief.
Mm.
My lord.
So here also let them continue with the internship.
Yes.
You are in the
Lordship.
internship. Let them continue. In the meantime, you file your affidavit.
Lordship. It
And
may be
Mr.
clubbed
Bora
together,
is
my lord.
also there. Huh?
Both may come together, my lord, on the next day. Both items.
Similar matter, right?
My lord.
Okay. Heard Mr. S.B. Loskar, learned counsel for the petitioner, and Mr. B. Gogoi, learned standing counsel for
My lord, Srimanta Sankadev University of Health.
B. Gogoi. You are
Yes.
for
I am
Mr.
For the university, my lord.
University.
Yes, for respondent number 5.
My lord.
That's one number 5 and 6, my lord.
B. Gogoi.
Yes, ma'am.
Respondent number 5 and 6. And Mr. Bora, you are for?
I am for respondent number 1, 2, and 7, my lord.
Mr. Bora for 1, 2, and 7. And what about 3, 4?
3, 4.
Notice.
My lord,
Homeopathy Education Board, National Commission for Homeopathy.
Yes.
Notice will go. Petitioner to take steps for service of notice upon respondent number 3 and 4. The grievance of the petitioner in this instant case is that they had passed the 4th semester, or what do you call for this? They have successfully passed the 4th BHMS examination, and they are doing their internship in Srimanta Sankadev University of Health Sciences, Bhangagar, Gauhati. And while they were doing their internship, a notification was issued that they have to appear. There are a number of, yes, they have to appear in their 4th BHMS examination. As the 4th BHMS examination, which was already conducted, was declared to be null and void for the reason that the mandatory period required between two examinations, that is 6 months, had not elapsed between the third BHMS examination and the fourth BHMS examination. Per para. On the said facts and on the stated facts and circumstances, it is noticed that it was not the fault of the petitioner
The principal to confirm.
in the entire in the entire course of events, and as such, they cannot be made to suffer. Accordingly, this court deems it fit to allow the petitioners to continue with their internship along with their stipends for the time being without making them appear in the examinations, which are scheduled to be held in June, like this, which are scheduled to be held in the month of June 2026. Issue notice, returnable by 3 weeks, not 3 weeks. No, this is fixed on 1st of June, right? Issue notice to the respondents. Mr. B. Gogoi accepts notice on behalf of respondent number 3, respondent number 5, and Mr.
5.
B.K. Bora, learned counsel, accepts notice on behalf of respondent number 1, 2, and 7. 1, 2, and 7. Oh, B is a B, 5 and 6, huh? Extra copies be furnished by the learned counsel. List this matter along with WPC number 2600 of 2026. Let the matter be listed on 1st of June 2026.
My lord, one minor correction, my lord. They are doing the internship under the homeopathic college, not in the university. Lordship has recorded as the university. They are doing the internship in the college. Only on that part.
To continue with their internship, which they are doing under the
In the my lord, SJ and homeopathic college, Gauhati.
they are doing under the homeopathic college Gauhati. Which they are doing under the homeopathic college Gauhati. Internship. Otherwise, fourth examination was from Shankardeva. Right?
Yes. No, Sankar University is the examining authority, my lord. Affiliating authority, not the college, my lord.
Okay.
Not all the petitioners, petition number 1 and 2, they are on internship, and the other petitioners were not allowed to join in the internship.
Acha, petitioner number 1 and 2. Petitioner number 1 and 2 are continuing with their internship.
Yes.
Where is that? Where have you written it?
My lordship. My lordship, I have written it on.
Paragraph?
Paragraph I have specifically written.
Paragraph 18, it is there, my lord.
Wait, paragraph 15, my lordship.
18.
18. Stipend has been stopped, my lord. That's why I'm not allowed to join.
Acha, they were to commence the internship training, but that was invalidated. You are not doing internship.
My lord, petition number 1 and 2, they already started. In case of other petitioners, my lordship, they are about to start, but the result has been declared null and void.
So you write only 1 and 2 to continue with their internship. And to receive their stipends, only 1 and 2.
Yes.
And they may not be allowed to, they may not be forced to sit in the examination, huh? And what about 3, 4, and 5?
My lord, other petitioners, they are already passed, and their result has been cancelled. Then only
And respondents and petitioner number 3 to 6 may not be forced to appear in the, may not be directed, or what I said? May not be directed to appear in the examinations again. It is in the fourth BHMS examination. Full stop. Then list this matter on 1st of June. First of June, we'll have to, Mr. Gogoi went. Mr. Bora, 1st of June, we'll have to decide the matter. Otherwise, they will be hampered with the examinations and all.
My lord, we will file the affidavit by then. We'll file the affidavit.
Written SSO instructions at least.
Well,
But in this matter, lordship, I pray for an accommodation, lordship, because I know, lordship, this is all pending cases, lordship. But problem is that, lordship, this matter is very hard physically, lordship. Lordship, may kindly fix this matter on 9th of June, lordship, subject to continue.
Acha, so even the other side, I think, wanted time so that,
No, lordship,
right?
This matter, no.
Not this.
Not this
Acha,
matter.
acha. So this is item number
12, lordship.
12. So, okay, as prayed for by the learned counsel appearing for the petitioner, list this matter on. You could have come. I mean, your senior could have come today. There is no bar that persons cannot come.
Still, there is a full court.
Okay, as prayed for by the learned counsel, the petitioner, list this matter. When do you want?
9th of June, lordship.
On 9th of June. Okay.
Deeply okay.
What about Mr. Rahman's advocate Nahil? Okay, item number 15. Yes.
These are the matter for the time being.
Time being. Okay. After some time. Yes, Mr. Rahman. 16.
Let me start.
Who was supposed to come? I forgot.
Higher secondary main.
A main higher secondary education.
Yes, they are
Mr.
presenting.
Yes,
Gogoi
Wapanga.
was giving this matter, my lord.
D. Gogoi.
Yes.
Oh, Dikshit Gogoi. He's not there in the court.
He's on his way, my lord. He was
Let me start from my side.
Okay,
water
let's
blocking. He was
Uh-huh.
water blocking. He couldn't come on time. He's on his way. my lord.
Achha. Okay, let the case be started. Yes, Mr. Rahman.
So here, lordship, this is a list of dates I have here for the court.
Okay.
So here. So petitioner before your lordship, he is the lecturer of the Naharpatia College. He was appointed on 1/2/86. So college was provincialized on 1/12/2005. College was provincialized.
Achha, just let me go through the documents.
Lot.
Take me through. So petitioner's name is what? Purobi Borua. Achha. So she was first appointed as a
As a lecturer.
lecturer in
but
Naharpatia.
was Non-deficient. 1/2/86.
Page.
Lordship.
You have not annexed.
No, it is not there, but I will state it.
1986, she was appointed.
He was appointed. Thereafter, when the college was provincialized in 2005. So as the college was provincialized, her post is also provincialized. Then now.
But I think both are separate procedures.
No, they are provincialized there because last occasion that question was raised. That's why I said, well, no, that she was already posted provincialized. That is in the affidavit. I will come to that. Here, lordship, dispute starts it on from item 4/3/2021. Because I take leave on medical grounds 20. So when I was taking frequent leave, So I was not allowed to join in the college. Rather, they advised me to regularize my service. So on 4/3/2011, I was directed to go to the Assam Medical College for medical examination, whether I am fit or not.
2011.
2011, 4/3/2011.
Mm.
Finally, Lordship. That is the, so thereafter, so I attended, the petitioner, I attended the medical board. I have appeared before the medical board. Thereafter, outcome of the medical board was not informed by anybody. So I was insisting to the college authority to allow me to join. But
So what happened to the medical board, you said?
that is not communicated to me, because letter was given by principal directing me to go to the medical college. Accordingly, I attended the medical college, but outcome of the medical college is not informed. Thereafter, Lordship, what happened? I was regularly insisting the college authority to allow me to join by submitting one after another letter, which were admitted in the affidavit also. But I was not allowed to join till my retirement. That is, my superannuation comes on 3/11/3/12/22. That 11 years. I could not take a decision on my medical, whether I am fit or not. That is the admitted fact in the affidavit. Lordship. Then now I come to the affidavit, what they have submitted regarding this. So here, Lordship, kindly take to the affidavit number 2, there is respondent number 2 affidavit. That is the affidavit filed by the Director of Higher Education.
Yes.
Here, Lordship,
Page 95.
that is,
Continuing page 95.
yes, an affidavit filed by the respondent, Director number 2, Director of Higher Education. Lordship got it?
Director of Higher Education.
Higher Education. 2 affidavits are there, one from Director of Higher Education, another from the college. I take to the Director of Higher Education.
Very sorry, my lord, I was stuck in rain.
No, it's okay.
I got drenched and again I went back and changed and came.
Oh, there is rain outside.
Yeah, it's raining.
Oh, we entered before the rain started,
Yeah.
so we didn't know. No. Acha,
Stuck
so,
in mid.
okay, yes, Director of Higher Education, what did she say?
I'm not for the higher education, I'm for the
No, no,
college.
No,
okay,
he's
okay.
continuing with his argument. I'll come back to you.
You are anyway,
Yes.
Lordship, this is the affidavit filed by one Pomi Borua,
Huh.
the Director of Higher Education. Paragraph 3, kindly look.
Paragraph 3 is deems it appropriate to
Yes,
place
yes.
the relevant and material facts.
Yes.
Yes, then?
Paragraph 4, that her appointment was against the post-sanction. That is 1, 2, 3, 4.
Yes, yes, post-sanction,
Post-sanction.
which was approved by Director.
87, which is approved by the Director of Higher Education Assam, with a 86 by so her service was confirmed with 9/12/93 by order dated so and so. Then I skip to the next page. That it is pertinent to mention here that the petitioner was placed at a senior scale of pay so and so. Next increment so and so by order dated so and so.
No, where? Paragraph 5.
Next paragraph, after 4.
5.
No, not that, it is continued.
Oh, continuing, yes. Oh, yes, huh.
It is pertinent to mention here that the petitioner was placed at the senior scale of pay with date next increment so and so, and she rendered continuous service up to 21/2005. Number so and so dated 21/6 and the relate there that the answering the opponent beg to state that as per report. So it is not his information, all the reports from the college authority. So 6 also, that the answering opponent beg to state that the principal Nahakote College Dibrugarh by later
So all information from the principal.
principal, yes. So thereafter, the paragraph 7. 7, I come to this last pay. Authority has allowed to pay based on principle no work, no pay. The petitioner sent application for leave on medical ground from time to time, but after provincialization of college, that is 1/12/2005, she has not earned any earned leave as she is absent after 2/25/15. Further, there is no leave on a medical ground as per Assam Medical Emperor. So. The next application, next stated that this answering department beg to state that as per Assam College Provincialized rule, clause 8 states, employee who retired died. This is not applicable in my case because I have neither retired nor died. So, but they have replied on paragraph 8 also. So this is the affidavit filed with the, then next affidavit 3 and 4.
So her contention is that she has not had any earned leave.
I have not earned. that is accepted. I have not disputed that one.
Mm.
But my dispute starts from the medical report, from the day of medical fitness. So Lordship come to respond number 3 and 4.
Mm. Their affidavit, yes. Affidavit by 3 and 4.
Yes.
Wait, this is your reply. 3 and 4. Any continuing page there? No. Ouch. Yes, 3 and 4, huh?
Three and-
Hmm?
So first affidavit 2.
3 and 4 are what? Principal?
Principal and the governing body.
Acha.
So here, paragraph 4,
Hmm.
that the deponent beg to state that the petitioner has been remained unauthorized absent, that from the duty, so the deponent humbly state that petitioner was found fit to resume duty, standing medical board on 21/3.
So she's found fit. This is the report or what?
No, this is submission by the principal of the college.
So this is the report of the medical board, which she said.
His statement,
Hmm.
let me finish it. So
Found
reached
fit.
on 21/3/11, however,
Hmm.
the petitioner did not report her duty.
Hmm.
It is claimed by the petitioner that since the 2010, the petitioner was seeking permission from the deponent to allow her to join.
Hmm.
The deponent humbly states that the sake of formality, the petitioner had applied application on 2 occasions. That is, before the deponent office seeking permission to join. That is admitted fact that I have applied for
Hmm.
permission.
Formality's sake, you had given 2 letters.
On record, I have annexed all.
Mm.
All. I will come to that one.
Hmm.
Paragraph 6, Lord.
Hmm.
That deponent beg to state that from plain reading from the writ petition, it is portrayed that the petitioner is aggrieved by the action of the deponent for not allowing her to join her duty
Hmm.
on 2000. It is stated that the petitioner has been absent since 27/1/2005 to 2008. The petitioner applied for extension of leave for 3 months. It is stated that only on 26/9/10, the petitioner made another application seeking permission to join her duty after remaining absent for 1 year, 7 months, after 20 days, without leave application. It is it's also stated that on 26/9/10, the petitioner neither make any application for the unauthorized absent nor produce any medical fitness certificate. Again, on 25/10, the petitioner failed to produce any medical documents. Then paragraph 7, then paragraph 11. 11.
Hmm.
That with regard to the statement made in paragraph 5 of the writ petition, the answering deponent begs to state that by letter dated 2011/8, that the then principal informed the petitioner to complete formalities for explaining her absence.
Hmm.
It is stated that in the said letter, it was specific that she had to apply for regularization from 27/10/2005. Then I skip to paragraph 13.
Hmm.
Paragraph 13. That with regard to the statement made in paragraph 7 of the writ petition, the answering deponent begs to state that the letter dated 13/8/10 was communicated to the petitioner on a routine process adopted by the institution, which is also done for all employees.
Hmm.
Then I have come to the paragraph 16. 16 is very important.
Hmm.
16 of them. That with regard to the statement made in paragraph 11 of the writ petition, the deponent herein state that the petitioner was found fit to assume her duties by the standing medical board. However, the address of the petitioner was wrongly recorded in the medical report. Accordingly, by memo number 7 dated, the address of the petitioner was rectified. The matter was prolonged absence without sanction leave of the petitioner and her physical fitness certified by the standing medical board were conveyed to the Director of Higher Education, Government of Assam on 13/11/12, and the college was awaiting on the direction sought from the Director of Higher Education. On 24, the college submitted medical certificate and report to the medical board to the Director of Higher Education for information and necessary action. On 3/11/12, 10/1/13, 19/3/13, and 27/4/13, the college has communicated to the Director of Higher Education, reminded frequently to expedite the matter as the earliest. In the meantime, the petitioner on several occasions had filed several applications by post to permit her to join. So this is an admitted fact. I have applied one after I have submitted my application, but they took this the time from 15/1 to 22 till my retirement to take a decision for my medical fitness certificate or not. because matter was referred to the Director of Higher Education. In the Director of Higher Education, it was pending for 11 years.
My director education was pending for what? Considering her medical certificates.
That they know, because their statement is standing medical board, fitness certificate, and everything was sent to Director of Education. It is an affidavit. So they have not taken any decision till my joining.
But on the other hand, she has not attended to her duties.
Now, how come? Because I repeatedly, I sought my permission, they have not allowed me. It is admitted. Last paragraph. Same, last paragraph.
To permit her to join duty.
Yes.
And that permission has to be given to her. Otherwise, she
No.
cannot go and simply join.
No, even I approached the principal personally, but say only say information is in, your case is pending with Indian Director of Higher Education.
She was working as what?
As a senior college lecturer.
Lecturer.
So thereafter again.
What is her ailment?
Nothing.
What is her ailment?
That arthritis and something.
Arthritis.
So in the paragraph 17 again,
Mm.
that with regard to the statement made in paragraph 12 of the resolution, deponent offer no comment as it is a matter of record.
Mm.
It is stated by letter number so-and-so 13, the Director of Higher Education Assam had informed that the governing body of the institution is authorized to sanction all kind of leave except study leave in respect of teaching and non-teaching staff. So this is the reply again from the Director of Higher Education that principal of the college and the governing body, they can take all the decision.
Mm.
Then paragraph 22.
So that was written by the higher education, right? গৰম পানী দিবা, huh? Yes. Mm.
That paragraph 22.
Hmm.
That with regard to the statement made in paragraph 22 and 23 of the writ petition,
Paragraph 22.
paragraph 22,
Huh. Yes.
that with regard to the statement made in paragraph 22 and 23
Mm.
of the writ petition, the deponent humbly states that as stated in the letter 3/12/22 and 13/1/23, these are the two letters that is after my superannuation.
Mm.
The deponent informed the petitioner that as the disciplinary matter pertaining to the service of the petition at the Nahar particulars are already submitted to the Director of Higher Education, Government of Assam for necessary action. The deponent was neither in a position nor the competent authority to provide any information regarding the status of the post. So this is the statement made by the director. This is the principal.
Acha, by that time you had superannuated.
Yes, I was running after pillar to post for allowing me to join. I was not allowed to join. Ultimately, my superannuation date comes. So, so here again, paragraph 24 also it is admitted petitioner has been submitting application for leave extension time and again without regular. So my application they have acknowledged it. It is not disputed that I have not submitted my application. It is not disputed by the affidavit that I have not approached the authority. But it is there, I do not know whether ego fighting or something because between the principal and the higher authority to take a decision for my resumption.
Higher authority had taken a decision that managing the board,
So
they can do it.
that because they are the authority. Whether
But higher education said that except for lien and leave, study leave,
yes,
everything is left on the governing body of the
Governing body.
institution.
yes,
So governing body has to regularize her leave period.
they are the authority. Principal and the governing, but principal is the secretary of the governing body.
And without regularizing a leave period, she is allowed to superannuate.
Yes.
And then the issue is now with the
So
money.
If we two now, first is whether I am entitled for the pension or not.
Mm.
Because as per the Provincialization Act, there I am entitled for the pension. It is admitted by respondent number 2 also in the affidavit. Come to again.
Respond number 2.
Respondent
Yes.
affidavit.
Where is that paragraph?
Paragraph 4.
4.
Yes.
Okay, that is sanction post confirmed and
Yes, yes,
everything.
everything is there.
She rendered continuous service up to 2005.
Yes.
So she is eligible for pension.
Pension, yes. So
Pension too, you want only 1 year of continuous service, right?
the pension is also there because for first period, prior to the medical examination,
From 93 to 2005, she is stated to have worked continuously.
she is entitled for the pension and all this. It is
After 2005, her leave started.
We've started that without, I am not claiming the salary for that period because I am on unauthorized leave.
Mm.
That is not regular. But from medical, the
2011 to.
2011, that is because when I am willing to join, they did not allow me to join. They are not utilizing my service. I am entitled, whether I am entitled for the salary or that period or not. That is for that. I like to submit some judgment also there.
But you should be allowed to join or what? When did you took
No,
leave?
never.
No, you took leave.
Yes.
For what to what period?
That is fast, frequent break after break sometimes. So that is
Off and
why,
on.
That is why I was sent for medical examination, because I was whether declared a fit or unfit. So medical I have appealed. So medical they have declared the fit, but that communication is not given to me. That is
Because
sent
the address was wrong, they said.
That is there. It is not my headache. Then all papers are sent to the director for taking a decision. Now it is the authority. Till my retirement, they have not taken a decision. So now who will respond? I was willing to.
So now you want your pension benefits and
As
then
well as the salary for that period. 30.
from 2011 to 22.
20. And for that, I am entitled as per the case law. I cited Supreme Court judgment is there. Our High Court judgment is there. When I am willing to perform my duties, they have not allowed me to join. That for I am not responsible. So they are bound to give my salary or for that.
You are not claiming for the period 2005 to 11.
Okay.
5 to 11, you are unauthorizedly absent, so you are not claiming.
I am not claiming that.
2005 to 11.
And
From 11 to 22, you are claiming.
Yes. For that, I like to say.
And from 93 to 2005, you are regularly. Okay.
So here, let's say, because my affidavit have not replied in para-wise, but particularly my allegations are not replied. Kindly see this. The affidavit response number 2, in my read petition, paragraph 9 of the affidavit.
No reply to 9.
No reply to paragraph 9.
No comments.
11 and 13.
No comments to 9.
No, that is paragraph.
11.
No, my affidavit, no reply in paragraph 9, 10, 11 and 13.
11 there is.
No, para 9 of their affidavit, it is not
Response number 2's affidavit.
Yes. Kindly see affidavit.
Response number 3 and 4 had replied.
3 and 4, no, they have also not replied in some paragraph. I'll come to that. But paragraph, this response number 2, paragraph 9 of their affidavit, they have not reply in my read petition, paragraph 9, 10, 11 and 13.
They have not made paravas reply, I think.
Yes, no paragraph.
No paravas
No
reply.
paragraph. Then
They have put their own contentions.
that is their contention, like a story they are mentioning.
But
And
we have response number 3 and 4 had written paravas.
3 and 4, in reply to my statement in paragraph 9 and 10.
Not there.
Their affidavit, paragraph 15, kindly look into.
Yes, not there. No
Not there.
comments.
Answer independent as no.
But 11 there is reply.
Then 16, in para 16 of the affidavit, reply of the 11 of the petition, that is 16. 17 of the affidavit, reply of the para 12 of the petition. Kindly look in the display. 22 of the affidavit, reply to the para 22, 3. So these are the reply. So now for that period, whether I am responsible, I should be penalized or not. That is my question.
Okay, what are your judgments?
Yes, I am citing. First one is no reply in the affidavit.
No reply in the affidavit, then we'll consider it as admitted.
No, yes, that is.
So that is a settled
1998
position.
GLT.
That is settled position. We will consider it as admitted.
Even then my duty is to.
Yes, yes. No reply in affidavit, so admitted.
Then for the no work, no pay, this is 2018 3 GLT.
1981, 1988 1 GLT 544 paragraph.
That is the no reply.
No reply.
That is the second paragraph. The paragraph 4, 5 is like this. Read petition and the counter affidavit. Not only facts, but evidence in proof of such fact must also be pleaded. Denial to the specific and not evasive. Practitioner pleading how to be made when faulty. Here 19 will referred. Paragraph 4. So second one is 2018 3 GLT.
This is on what?
This is I am willing to work by my service was not utilized. That's why I am entitled to a salary. Then third one is 2016 16 SCC. fault of not utilization of service of the employee concerned being employer. Yeah. So I'm referring three judgment on that one.
The second judgment by Justice Bujo Borua is for willing to work, but it was not allowed.
Yes.
And the third Supreme Court judgment is for
Same.
same.
Service is not utilized by the authority.
Okay, these are the three judgments. Yes, Mr. Dikshit Gogoi? She,
I think he has to respond first, the higher education.
Acha, Mr. Upamanyu.
Yes.
See, her service period can be categorized into three parts.
Yes,
To 1993 to 2005, was stated
Yes,
to be in
till
continuous service.
Yes, till 25.
2005 to 11, she is not claiming because she was under unauthorized leave. 2011 to 22,
11
she was trying to join. She had also approached the principal, but she was not allowed.
No, Lordship.
So
Her,
her leave, her documents were also not considered by higher education, by the director
Lordship, for that, Lordship, may I read para 5, Lordship,
of
of my affidavit, Lordship?
respond number 2,
Yes, Lordship.
director.
Yes, Lordship.
Yes. Paragraph
5, page 89.
5, yes.
May I read, Lordship?
Mm.
That the answering deponent begs to state that as per report received from the principal of such and such college, the petitioner remained absent from her duty with effect to 27/1/2005 to 13/5/2005. That is for 3 months, 17 days. She submitted an application dated 6/2/2005 to consider her leave for 6 weeks on medical ground with effect from 27/1/2005. Subsequently, she submitted 2 more applications dated 28/2/2005 and 9/3/2005 requesting extension of her leave on medical ground. Thereafter, the petitioner joined her duties on 14/5/2005 Saturday and from 15/5 to 36/2005 the teaching department were closed on the account of summer vacation. After summer vacation, she attended duty on 1/7/2005, that is for 1 day only, but remained absent with effect from 2/7/2005. The petitioner again applied for leave on medical grounds for 2 months with effect from 2/7/2005 by the application dated 11/7/2005. Thereafter, Lordship, availing leave for 2 months, the petitioner did not resume her duty on 2/9/2005. She submitted an application dated 2/9/2005 for 6 weeks leave extension with effect from 2/9/2005. Thereafter, she continued sending application for extension.
So many applications of
Only application after application. But Lordship, no one asked her to stop coming to the duties, Lordship.
That is okay. That he had admitted 2005 to 11.
Yes.
He is not claiming also. But
After-
but 2005 to 11 are many years, 6 years. So 6 years, can it be regularized?
No, Lordship. Thereafter, Lordship, she was claiming VRS, Lordship. They have annexed, Lordship. In 2010, Lordship.
She applied for VRS?
Yes, Lordship.
Where is that?
Lordship, page 45, annexure 12, Lordship. Seeking for VRS after joining on duty. And Lordship, in that page itself, the reference Lordship may see, your letter number is dated 5/7/2040 for joining on duty. So Lordship, the college authority were asking her to join her duty, but she herself was claiming VRS after joining on duty.
The honorary resident after standing medical board's recommendation. This was in 2017.
Yes, Lordship.
After the medical board's examination.
Yes, Lordship.
After standing medical or allowing me to join the duty, I have been sending several letters requesting for the same. As per GB's review, it was sent a letter from your honor dated so-and-so, while letter date to join on my duty. Having received, I went to join my duty, however, was not allowed to join for. She went, but then she was not allowed to join, she said.
But Lordship, the college authority were asking her to join. And considering the greater.
One side saying college authority is asking her to join.
Yes.
One side saying that college authority is not allowing her to join. Now whom to believe? Here, see, she wrote the letter.
Yes.
That I have been sending several letters requesting, her English is also mashallah. As per GB's resolution, it was sent a letter from your honor dated so and so to join. That means principal had sent her a letter to join. Having received a letter, I went to join on my duty on 24/7/2014. However, I was not allowed to join for reasons not known to me. She was not allowed to join in 14. That is after medical examination.
Lordship, that the college authority will.
Now, I don't know. These facts are very disputed whether she was allowed, not allowed. Now, what about her pensionary benefits? Where is the impediment?
Lordship, since 2005, she never.
From 93 to 2005, she worked.
Yes, Lordship.
That is in your affidavit. Continuous work.
Yes, Lordship. But Lordship, she will not get the benefits, Lordship.
Why?
Because
Pension rule says 1 year of continuous work,
provincialization.
minimum.
Minus FRSR will come as an impediment.
Yes,
Because FRSR, FR18 provides a period of maximum 5 years.
Maximum
5
period,
years. FR18,
5 years.
FR18 matters.
So 5 years, more than 5 years she
It's
has.
more than 5 years, madam.
93 to 2005.
No, no, no.
Later part.
Later part.
5 to 23.
But she was appointed to a regular sanction post.
No, madam, a government servant has to, that if he goes on EOL, well, it's, except earned leave, my lord, he has to, there's a maximum cap is, my lord,
For
5 years.
Not beyond.
Beyond 5 years, it will be considered dice-non, my lords, not in service.
Acha, maximum gap of
Yes, 5
absence.
years, yes.
If it is more than 5 years.
Cannot be regular.
It cannot be regularized. Lordship.
Now here,
And from 5 to 11,
From-
if we count, it's 6 years.
oh, it's 6 years. Where is that FR? Show me.
FR18, my lords, will-
Their affidavit,
FRSR kon diya na?
their affidavit kindly go through paragraph 9, same affidavit.
Respond number 2.
Yes.
Yes. Paragraph 9. Okay, let them finish. I'll come back to you. 9, what did they say?
That the answering deponent may to state that as per report of the college, Provi Bolo petitioner has been working from 1996 as lecturer Department of Economics for Naharkota College, Dibrugarh, and rendered continuous service from 25/1/2005 to 25/1/2020, but the petitioner did not perform duty. Further, college authority has not allowed to pay based on the principle no work, no pay. Hence, the petitioner is entitled for service benefit with effect from 86 to 5. Total length of service 18 years, 11 months, 24 days only, and the period of 25 till date retirement. Her service may be treated as no work, no pay, and she may be entitled for pensionary benefit. So I am not claiming the salary.
How come 86? She was appointed in 93.
No, 86 initial appointment.
Ah.
Regular is 2005. It is
With
their
effect from
affidavit.
93.
I am reading their affidavit, it is not my paragraph 9.
So total
Pension
length.
benefit, that she may be entitled for pensionary benefit with effect from 1 to 86 to 2005. Total length of service 18 years, 11 months, 25 days. How they can argue now on that point now? It is an affidavit filed by the.
As per
Director
clause 8 of Assam College Employees Provincialization Act. So if her service is considered from 86, your affidavit only shows she is entitled to pensionary benefits. Service benefit.
No, Lordship, that period will stay, Lordship, but after 2005. She is claiming after 2011, now she is claiming, Lordship. Till her date of retirement, Lordship, she is claiming.
No, that is.
So
I am
till
claiming the
2005,
salary. That from the medical, from the date of medical fitness, my service is not allowed till my retirement. So that period I am claiming my salary. But
Here it is
that-
said, of course, that period you cannot because no work, no pay.
Yeah, they have treated that. But as per this three.
But pensionary benefits, she's claiming that prior
No, that is-
previous
that
service.
is-
that is, Lordship, that will stay, Lordship, till 2005. But after 2005, she will not get anything, Lordship.
Yeah, that is a contentious issue that she was not allowed to join. So no work, no pay. But pensionary benefits, you cannot deny, you yourself has said.
We will be taking the last date of her service, Lordship, that is 25/1/2005.
2005.
Yes, Lordship.
Until then, she has worked for 18 years.
Yes, that we will consider, Lordship.
For pensionary
Yeah,
benefit.
but not after 2011, which she is claiming, Lordship, all her arrears and all, that we cannot, Lordship. Because then, Lordship, that thing will come beyond a period of 5 years, Lordship.
So Mr. Rahman, that period, no work, no pay because.
No pay, I am not claiming. But when I was prevented to work, as per the judgment, I am entitled for the salary of that. Whether the court to decide on that point, because I am submitting 3 judgments. Number 1, they have not filed affidavit in a parawise comment 2. So without filing the, when pairwise comment is not replied, affidavit is not specifically denied, that is, it is treated to be admission.
And you have also stated, Mr. Pomenyu, that the documents were sent to the director, but the director was
Yes,
sitting
we
over.
have not-
No, no,
it is
we
there
have not
admission.
stated that the college authority has stated in the.
Acha, acha. The principal had said.
Yes.
And so he was sitting over. And lastly, he said that it is for the managing governing body to decide.
Yes.
Mr. Gogo, you are appealing for the principal.
My lord, yes, 3 and 4. My lord,
So
that,
as
that
far as-
very, that very contention, my lord, not
As
replying.
far as, as far as Upamanyu is concerned, he said that pensionary benefits for the 18 years, okay, she is entitled.
Yes.
But later on, he's saying that she did not
Yes,
work
yes, yes.
in spite of letters by the principal to requesting her to join. But then there are disputed facts that she had,
Yes, my lord.
she
And
was
that-
not allowed.
And on that count, my lord, we are on the same page, my lords. Man, we are not denying 93 to 2005, 86,
Uh-huh.
86 to 2005, we are not denying anything. But my lord, that very contention, I have to address my senior, my senior, that paragraph 9 and 10, we have not denied, said nothing. Lordship will kindly go to paragraph 9 and 10 of the affidavit, my lords.
9 and 10 of your affidavit.
Yes, no, my lord, read petition, my lords.
Oh. Yes.
9 and 10, these are averments of the petitioner on the ground of medical, which we cannot say anything.
Huh, she appeared
Yes,
for the
yes,
medical board.
that is her case. That is as a college authority, we cannot reply to that she appeared or not, my lords, because it's for the medical board and we did a petitioner, my lords. That very contention, that very
Who is respondent number 3? Principal.
principle, my lords.
So she got a letter from the principal asking her to
No,
go to
9 and
appear.
10. I'm addressing 9 and 10, my lords.
Para 9 and 10.
Para 9
Where
and
is
10.
9 and 10 only?
9 and 10 then. My senior, my lord, is submitting that 9 and 10 we have not denied when we applied.
Reading 9 only. 9 of these petitions. Yes.
As per number
9 of
three.
the petitions.
My lord, no, what I'm trying to convey is, my lords, that 9 and 10, she was asked to appear. She appeared.
Mm.
That is not denied, my lords. That is, she was asked to appear. She appeared or not, we cannot deny that, my lord. This is not denied. We issued the letter. That is on record. And 10, my lords, she has appeared. 10, we cannot say anything because it's whether she appeared or not, that's a different
Yes,
thing, my lord.
okay.
And my lords, that
No, she appeared because
yes, she
after
might
that,
appear. She
after that, your affidavit says that she was found fit.
my lord, she has appeared, my lord.
Hmm.
And then, my lords, there's no quarrel to that 86 to 2005, my lords. There's no denial of anything. But my lords,
But after 2011, after she appeared before the medical board and she was found fit, she wanted to join, but the principal did not allow.
my lords, that is a contentious issue because there's no rule, my lords, as such which bars and asks her to go in, my lords. She just sent letters, my lords. She has never appeared before us. She had never gone to the college. She just sent some letters, applications, and seeking that I have sent this and that, I have sent this and that, let me join. But she has never physically visited the college. One has to join her service or his service. One has to go there. An intention to keep away from somebody to work is also, my lord, not fair on our part also. We didn't do anything. The college authorities were wanted her to come because students are suffering. That also we have stated in our affidavit, my lords.
Where? Your affidavit says that a petitioner was
24, my
found
lord.
fit to
Para
resume.
24.
Paragraph 4, you said that petitioner was found fit to resume her
Yes, madam.
duty.
Yes, that's
Right.
no denial, madam.
However, the petitioner did not report to her duty.
Yes, madam.
Was seeking permission for sake of formality. But then still, you have to reply to the letter allowing her to join.
Then, my lords, what had happened, my lords, since we are not the authority who can regularize our leave. So we wrote back to the authority, competent authority as a higher education.
Who has to regularize her leave?
The government, my lords, government has to regularize. FIR has to be invoked by the government because the appointing authority is the, my lords, the controlling authority is the higher education, my lords. FR 18 or whatever FR, my lords, even they have to invoke it. We cannot do anything because they are the paymasters. And in paragraph 24, my lords, of my affidavit, we have said, my lord, we have averred that she, without any sanction leave, she, my lords, the
Remain
petitioner
absent from her
absent.
duty without any sanction leave.
Hmm.
Reply to livelihood.
And then, my lords, I fall back to my judgment of no work, no pay, my lords. Way to Airport Authority, Sabuna Das.
What is the judgment?
So this is Airport Authority of India. It's a Sambhuna Das and reported in 2008-11 SSC 498.
Paragraph?
Now, this lays down para, my lords, will find the penultimate paragraph. It's paragraph 6, my lords. In this particular case, my lord, the petitioner, my lord, the appellant therein, my lords, remained absent from work from 15 years. And then, my lords, the the apex court held that no work, no pay will come into play. And, my lords, the relief of 50% back wages was denied, my lord. Initially was granted by 15%, 50%. No. Even, my lord, the opening paragraph tells us there's a mention of a medical board. Medical board finds the petitioner fit to, my lord, resume duties, but for reasons best known to him, my lord, he doesn't appear, my lords. Then he goes to High Court, my lords. Then he goes to again the division bench. The college did everything they can in their capacity, my lords, to. Had been, my lords, there been any order of termination, had there been anything, my lords, which has stopped on record, my lords, to stop her from coming and join the duties, my lords. There's nothing, my lord, except this contention that she was sending few letters. And in the meantime, she files for VRS also. All along, lords, you will see the documents, they have also annexed, my lord. The college authorities were always, my lords, cooperating with her, my lord.
I've not gone through their documents, not even one.
Hmm? 40. My lord, from page 41, lords, you will see the college says, come and join.
This was in 2014.
My lord.
Then after she had joined, on 24/7/2014.
No,
Then?
that these are only on paper, my lords. The relaxation of hours here.
She wanted her period to be regularized first,
Yes, my lord.
and then she will join.
My lords.
And then what about this 18/12/2017 letter, where she said she was not allowed to join?
That we deny, my lords, because she never went back to.
I went to join on my duty on. So she physically went to join, but she was not allowed.
That we deny, my lords. Nobody is disallowed for like such a serious post, my lords, professor of a discipline like economics, my lords, and that too from such a prestigious college, my lords. There's no we are denying, my lords. She never went there,
So she has applied for VRS.
my lords. Subsequently, she, that part, my lord, VR is accepted not by higher education, will say, my lord.
See her next contention. Now, considering the greater of the college, I decided to opt for taking voluntary retirement from my service after joining on duty if the pensionary benefits are given to me. She is more concerned with the pensionary benefit.
That we have no,
Mm.
no dispute, my lords. At 86 to 2005, my lords.
Mm.
In fact, my lord, FR 18 stipulates that, that after you cross that 5 years bar, you expose yourself to a DP, my lords.
That was not done.
That was not done. That's a different case, my lord. And my lords, okay. My lord, also see, my lord, from page 49, 49 to 50, lordship,
See all
postal
this.
endorsements are there.
Hmm?
She never physically visited a college, only
Hmm.
postal endorsements, my lord.
Mm. These are all letters.
Letters, my lord, that's true, my lord, also postal endorsements, my lord.
It's all letters, but then she came once when she first applied for VRS, she said.
Yeah, that VRS, my lord, we replied back, that we have the authority to decide your VRS.
Yes.
At 51, you apply to the competent authority, my lord.
I will need to join.
And those letters, my lord, with due respect, my lords, those were, my lords, there's no receipt, there's no endorsement of anything to confirm whether they are actually received or not.
Mhm.
Actually sent or received. Page 42. We received the VRS letter, we replied in a prompt manner, my lords, that we are not the authority. Until now, my lords, they have no doubt, my lords, she should have applied to the competent authority, my lords.
Then she wanted her status of her post.
Yes, ma'am.
There are so many communications. It's okay. Then final regularization to Director of Higher Education. What happened to this representation, Mr. Rahman? Director had replied, regularization of leave and
Right? Because I have comment on no reply as it, now it is a, now I have seen two affidavits are contradictory. One, the principal, he has based upon this, the authority, that they are the authority. But in reply to the letter of the college authority, that director wrote to the authority that you are the person, governing body is the person for regularization of leave. That is the admitted facts of it. But in spite of that, my leave application has not been forwarded, not been regularized by either by the governing body or by the authority. They are now transferring the responsibility to one from another. Now, second point is, when I was supposed to go to the medical board, by whom? Who has directed me? That is the principal of the college. Directed me to attend the medical board, whether you are fit or non-fit because you are frequently absent. I attended the medical board. So medical board, they have not given me any papers. I have handed over the memo which college authority has handed over to me. I have handed over to the medical board. Medical board they did not reply. Then thereafter,
But Mr.
Medical
Lee,
board is not a party, my lords.
huh?
Medical board is not a party.
Not
have-
required, not required. It is seen that they have,
Then I have attended the medical board. Then my report is come to the college authority. First is that address is defective. That is not my fault. They have corrected the address after 1 year. Then they send all the papers to the director of higher education. The director of higher education, instead of taking a decision, he waited for around 10 years till my superannuation. Now in the affidavit, kindly see the affidavit of this.
yes, I've seen.
Yes, 3 and 4.
But fact remains, of course, you have given certain Supreme Court judgments where it is
Yes,
said,
I have given 3 judgments.
but fact remains, no work, no pay.
Yes,
Admittedly, you have not worked a single day after 2011.
no, not single day.
2005, in fact.
No, 2005, I am not claiming anything. Because I know because I am unauthorized absent for such and such period. But from 2011, when I sent to the medical board, that my service is not utilized by the authority, which is admitted in their affidavit.
No, but then you were called by the principal to
No,
join the duty.
Where is the proof? Right,
There are letters.
Lordship, something we cannot prove because personal attendance, they have not taken the photograph, number 1. Number 2, my application, which they have not accepted, thereafter I am compelled to submit the application 1 hour after by registered post with due acknowledgement. Kindly, I like to.
No, that I have seen.
Yes, that postal
But,
letter is there. Postal, so where is the reply?
But then again,
No,
she
where
was-
is the reply? Suppose I wrote a letter to the authority, seeking permission. They have received the letter. Where is the reply?
Reply they have given. Few
Where?
replies are there by the principal. It is in your petition only.
No, that is only one line. That is page 41. Only page 41 is the repetition. I have annexed that one.
ERS application.
No, repetition 41. They have given me, you come and join. So page 42, I joined. I have submitted this report. It was not accepted. Then how will it go? Thereafter, I am compelled to file this application 1 after another by registered post. See the conduct of, because it is the fight between the inspector, the director of higher education and principal. By their affidavit, it discloses. It discloses. They are initiating a disciplinary that in affidavit they will
So
state.
she has joined on 24/7/2014.
Yeah.
She has joined physically.
Thereafter, college was holiday. They have stated that college was holiday. How I can go?
Or 24/7 was a holiday.
Holiday. Thereafter also summer vacation. So now you see paragraph 22 of the affidavit of this 3 and 4, they have categorically stated paragraph 22 of their affidavit.
Page?
3 and 4 affidavit page 76. Kindly go through this, what they say. It is ego fighting between the inspector of schools and the college. Disciplinary matter, that after my retirement, these letters are communicated after my retirement, after filing of this case. Letter dated 3/11/12/22.
Okay. I'll examine the matter and pass orders, not today. Because there are so many disputed facts, so I'll have to go one by one. Dictating will be difficult now. Not CAB, I will dictate it in the chamber. Otherwise, all matters will get postponed. Okay.
Next date. Any date? Any date?
No, disposed of. Today or tomorrow, you'll get the order. Disposed of. Yes, item 16. Hey, 115. Oh, I go to. Okay. Yes, Mr. Goswami, A to Muk chamber did was.
May I please your lordship?
Dispose of. Yes.
May I please lordship? Lordship, Mr. Dipankar Prasad Bora is on legs in another court. So matter may kindly taken up after some time. I'm calling.
It was already after some time and now again after some time.
Lordship, then I'm calling.
Is it ready for disposal? No, there are no affidavits at all.
Affidavit has not been.
Not required.
His lordship petitioner has retired from service as a principal of regional letters Gauhati
and thereafter he has been posted at Silchar. Ultimately, he retired from service in February 2020. His pension was not released. Ultimately, petitioner has approached his honorable.
Pension, Mr. Saikia can appear.
Thereafter, Lordship, provisional pension has been released as per order of this honorable court.
Acha.
Gratuity has not been released. Some payments are already due. Now, Lordship, they.
Some instructions are forthcoming.
Lordship, last order, Lordship will find order dated
6/5.
Lordship 2/2022.
22.
No,
Yes, Mr.
2
Saikia, you want to say
2026.
something?
The content general will be appearing, they will.
Oh, acha.
2 2026.
2/2/26.
Lordship.
So DP has also ended.
DP has ended.
The instructions are there.
My lord.
So they need some time to process the entire.
My lord, actually, it is in the final stage. The judicial department sought for some clarification. We have clarified on 25, my lord. So once we get the communication or the approval from the judicial department, immediately the order will be passed, my lord.
Okay, let them take, because it said multiple authorities are involved, so it's taking time. So Mr. Goswami, let them get the final instructions.
And initially, we had to obtain the approval from the APSC also. That also took some time. That has.
Okay, Mr. DP
Only thing is, Lordship,
Bora.
I do not know what order they will pass. Lordship, kindly 6/5/2026 order.
DP Bora, Learned Counsel. There is no response from the judicial. Reminder was sent today to the Joint Secretary. He submits that pending response on judicial adjourn the matter so that he can come. Yeah, directed to release the gratuity original specific and separate order. Yes, of course. That was given as a last opportunity to place the, but then he has placed one instruction. Certain clarifications were asked for. So many departments are involved, so it's taking time. Last opportunity was already given. So you bring the instructions by 2-3 days.
My lord, in that case, some direction may be given to the judicial department because we are communicating with them, my lord. Unless and until we get the approval order.
As per my information, as submitted by my learned friend on earlier occasion, they want to review the order of punishment as informed. You today.
Otherwise, DP is over, right?
DP is over and increment has been reduced. 2 increment has been reduced. They now, according to Lordship, for not formal information, that was the information given by my learned friend. They want to review the order of punishment.
They want to review the order of punishment.
Punishment. And there is a limitation, Assam Service Disciplinary Rules, Rule 7/27. It can be reviewed within 1 year. Within 1 year. My order has been imposed and punishment, order of imposing punishment has been passed in 2022. Now 2026. How they are going to review, there is no period of limitation also. There is no provision for limitation also. This is a never-ending process. And how petitioner will survive? Now they have stopped also the provisional pension also. From March 2026, they have stopped the provisional pension also. How person will survive? Now provisional pension has been stopped.
Can it be heard finally today?
Today, because we are going to pass the final order and everything will be subject to outcome of that order, my lord.
Okay, right. Heard Mr. S.K. Goswami, Learned Counsel for the petitioner, and Mr. D.P. Bora. Learned Standing Counsel for Health Department. By the last order, this court had directed the Health Department to come up with the order which they propose to make. But when the matter is called up today, Mr. D.P. Bora has placed an instruction given by the Deputy Secretary to the Government of Assam, Medical Education and Research Department, by which it was intimated that Judicial Department had sought certain clarification for vetting of disciplinary proceeding disposal order and pursuance of the same. The Department of Medical Education and Research had furnished the said clarifications and had sent it to the Judicial Department
On 25.
on 25/2026. And the said department, that is Medical Education and Research Department, was waiting for the, is waiting for the views of the Judicial Department for processing the matter further. Full stop. It is as such.
May I submit one thing, Lordship? Lordship may also record that I have got getting an information from March 2026, I have not given the provisional pension also, it will stop.
That could be done by whom?
By them, Lordship,
By Health Department.
by Health Department.
But Health Department is now waiting for the Judicial Department to
No, no,
give.
not regarding provisional.
No, not regarding provision. It is because of the DP.
Regarding review of the order of
Review.
punishment.
Review of the DP.
Lordship may record.
Which of course they cannot do also. 1 year period is over. Right.
My lord, that has
As such, it is directed that the Judicial Department should send their instructions to the Department of Medical and Health, Medical Education and Research Department within a week. It's a direction to the Judicial Department. They'll have to send you the within a week, commencing from today. That is, आज की तारीख लिखी दिया 25th of May 2026. They'll have to give it within 1 week.
Only thing is my submission also. At least Lordship, there is no order. My provisional pension was directed by the Honorable Court. Accordingly, that has been paid. Now, Lordship, March 2023, now June, I have not been paid.
Further, it is directed that since the department is taking long in getting the necessary instructions, the provisional pension of the petitioner, which was stopped from March 2026, should be paid without any delay. The arrear as well as the current, right? Delay. The arrear, that is from March 2026 as well as the current provisional salary.
My lord, actually, there will be some.
Provisional salary to you cannot
My lord,
deny.
because the proposed penalty that has to be sought, my lord. Already we have got the approval from the APSC. Now it is from the Judicial Department. Then after that, how will we recover from the petitioner, my lord?
My gratuity.
If suppose major penalty.
Provisional pension only.
Major punishment of dismissal or that is passed, my lord, then from where it will be recovered, my lord. So it's a matter of another hardly, my lord, 10-15 days. If within 1 week, Judicial Department furnishes the
Okay, 50% of provisional pension. Pay him.
How will survive, Lordship?
Otherwise, how will he survive?
But
Provisional pension to you are paying him even before March.
yes, my lord, it was paid. But now after the review of the order, that the penalty that is proposed to be imposed, my lord.
No, these are all presumptions. What penalty you will impose, and then you'll have to recover.
Yes, my lord.
But he was given
The
provisional.
balance of convenience, my lord, in case we have to pay, we'll pay him with arrear, my lord. But in case it has to be recovered, from where it will be recovered, my lord? So it's a matter of another
When
10, 15
survival
days,
of the
my lord.
petitioner is there, Lordship, how he live, Lordship? He is having
But
70
you
years
will
old person.
recover, you like you will recover for earlier months. Till March also you are paying your provisional.
Yes, my lord.
Then why did you stop? There are mechanisms from where you can recover. Right.
And otherwise, my lord, if judicial department furnishes its view within 1 week. my lord.
If I don't give this, even judicial department will take some time. So,
Yes.
okay. Provisional pension to be paid both arrear and as well as the current.
Obliged.
List this matter again on, when do you want?
My lord,
8th of June.
yes. 8, my lord, I have some, can it be on 8th June,
9th of June,
on 10th, my lord?
on 10th of June.
10th, my lord.
Lordship, he was a
My lord,
renowned doctor and he has, Lordship, retired from service in 2022, 20. Now, Lordship, why they are departmental proceeding, Lordship? Only AMC has been extended.
Mhm.
my lord, the judicial department order may be communicated by Mr. P. Soika. He is represented.
This order,
The petitioner itself, because we are not a party here.
No, but otherwise he may communicate, my lord.
Okay, but I am not a party. Petitioner may directly communicate.
communicate whoever petitioner you can
He
communicate.
can communicate, Lordship. He is the authority of everyone.
Mr. Bora, do it. He is holding pension.
Yes.
A copy of the order be furnished to Mr. D.P. Bora for onward communication to the judicial department.
Obliged.
Obviously.
Yes, Mr. Sharma.
My lord, this is my lord regarding non-payment of gratuity amount to the husband of the petitioner. And my lord,
Husband died.
husband died in 2020.
Yes, Mr. Datta, any
Yes,
instruction?
we have filed affidavit in opposition, Lordship,
Ready.
ready. But
Mm.
they have not filed a reply. I don't know
Reply
whether
is
he
not
have.
required,
Okay.
they are taking this, they are now passing the ball to one another.
Mm.
Actually, case was what happened, my lord. When the husband of the petitioner was headmaster of the school,
Mm.
there was a decision in the managing committee that some meal,
Midday meal.
Midday meal fund.
midday meal fund, my lord, from that fund, some amounts would be diverted to development fund for urgent need of some repairing of the school building. So it was the decision taken.
From midday meal fund, it was transferred to where?
Development.
Development fund. Okay.
So that school building was repaired and it was a decision of the managing committee, not the sole decision of the headmaster. Now, there are some objection raised by the auditor. Now this gratuity amount has been withheld. And the auditor has written this letter to the headmistress that this is not a misappropriation and it is a decision taken unanimously by the managing committee, not by the headmaster. So that gratuity amount cannot be withheld. Now, headmistress has said that we are unable to issue that non-liability certificate because this post facto approval is required from the director. Now, director has filed this affidavit, said that since non-liability certificate has not been issued, so we are not issuing this. How this ball is passing from one person to another. Now, this lady has been suffering for the last 5 years.
Yes, Mr. Datta.
Yes, Lordship, that is.
Pay the gratuity amount. And it is the decision of the managing committee.
Then Lordship hold, we cannot help.
Hmm?
It is, if Lordship held that this is a decision of the managing committee, petitioner is not liable, then we have no problem. But from our own Lordship, without getting the non-liability certificate from the petitioner's school Lordship, we cannot do this. Because otherwise this officer will be in trouble.
So, headmistress is saying what?
The
That
headmistress
is
is,
saying this post facto
no,
approval is
headmistress is
required.
written a letter to the director for to according as prospective approval in respect of that diversion Lordship. Actually, as per the report of the audit, Lordship, what transpired, that fund was allotted to the midday meal fund. It is for the children Lordship. But the headmaster, maybe with the, but the headmaster, with the approval of the SMDC or otherwise Lordship, has utilized the fund in some other development, purchasing furniture, etc. So audit objection is raised that since there is no, again diverted back the fund to the midday meal fund, that is showing that the Lordship, that the account has not been.
Ex post facto be granted by the director.
Director.
And then the non-liability certificate
Your
to be
Lordship.
issued by the.
Yes.
So you
Then-
get instruction or I'll direct?
Well, better direction should be given to that. If the
Because
direction
you
is not
yourself
given-
saying that it was by the, on the, what, on the conscious decision of the
No,
Yes, your lordship.
I am not
committee.
saying it is a
Your-
report
your-
from
your-
the auditor.
Yes, your lordship may kindly refer to
I
that
have to-
page 18, your lordship, NSS 6, page 18.
page 18.
Yes, your lordship.
Hmm? Yes.
This is a third paragraph. At the same time, from records and correspondence of the school authority, it was also evident that all the relevant utilization records of expenditure of rupees was available with the school authority, and thus it was not at all a matter of misappropriation. It was further revealed that the deceased HM late Chandan Harskumar, whose death come retirement gratuity is withheld from payment for on account of unsettled audio objection worth rupees 6,42,550, did not execute the decision of renovation of repair works independently, but it was an unanimous decision taken at the SMDC meeting dated 19 February 2017, my lord. So it was the, it
Okay,
was.
so yeah, you wanted to say something?
Yes.
Mr. Motin, Mr.
We need lordship, no,
School.
Mm.
we need a non, we need a certificate from the school,
Non-liability.
non-liability.
And they want a certificate from you,
Yes.
ex post facto.
That's the issue. That's the only issue.
Okay, I'll direct the
Post facto.
director to give you an ex post. Why keep his gratuity pending?
But lordship, one thing, the letter which the petitioner high school sent to us that no, for issuing the exposure is not available in our record. So the headmaster will have to send the letter again to us.
They have admitted in the affidavit. They have acknowledged that they have received. Lordship may kindly come to page 66.
Okay, but any impediment in sending you again?
Why you are fighting with your with senior officer?
Lordship, this,
No.
their quarrel is there. I'm just making a simple submission. Give a time frame that within such time, as post
Okay, you-
everybody is going to be.
I'm dictating, you correct me
Yes.
where I go wrong, huh?
Yes.
Heard Mr. Sharma? You Sharma, oh no, M Sharma, Learned Counsel for the petitioner, and Mr. P. Datta, Learned Standing Counsel for Higher Education, Secondary Education, Mr. P. Saikya, Learned Counsel for,
Response number 7, madam.
response number 7 is who?
That auditor,
Assistant director.
the assistant director of audit.
The Assistant Director of Audit and Mr. M. R. Odhikari for response number 5 and 6. That is the principal of the college,
Headmistress and
The
the
school.
managing committee.
the headmistress of the school. By this application filed under, एक dictation भी हुआ है, huh? By this application filed under 226 of the Constitution of India, the petitioner has prayed for a writ in the nature of mandamus, directing the respondents to pay the gratuity amount payable to her deceased husband, amounting to rupees 10,72,089. 10,72,089, which was payable on his retirement. The case of the petitioner is that her husband was working as the headmaster of Nehru High School, and during his tenure, a sum of rupees is mentioned or not?
Yes, 6,42,550.
A sum of rupees 6,42,550, which was meant for midday meal. I'm not seeing the petition, huh? I'm
Yes.
dictating as you have said.
Not-
There is no incorrect, I think.
not-
Meant for midday meal. So and so sum meant for midday meal was diverted to the development fund. And the said diversion was done at the behest of a decision taken by the governing body, managing
Managing
committee, SMC, School Managing Committee.
School Management and Development Committee.
School Management and Development,
SMDC, simple SMDC.
SMDC, School Management and Development Committee. However, the Learned Counsel for the petitioner submits that during the retirement, when the audit was done, it was found that the said amount of rupees 642,550 was missing from the midday meal account. And it was considered that petitioner had misappropriated the same. However, it is noticed that it was not the petitioner who had diverted the money, but it was on the decision taken by the SMDC.
Lordship, actually, it was not the audit regarding objection was not for misappropriation. Or that audit objection was only for that diversion.
Okay, let me see the petition then. Wait. It be stated here that the objection placed during the audit was not with respect to misappropriation,
Yes, sir.
but in respect to diversion of the said fund. But when was the objection? Why was his this amount was withheld?
The amount is because of that, my lord, because because of that audit objection, this amount was withheld from.
Since the objections were not settled, madam,
That-
why it will not issue that
Non-there is something.
That's why I want to.
Yes, and it is full stop. It is stated that since the objection raised in the audit was not settled, the authorities in the school could not issue the non-liability certificate to the petitioner's husband, in favor of petitioner's husband. Because by that time he died, right?
Yes, sir.
It is stated that husband of the petitioner died on 26/3/2021. And the husband of the petitioner had superannuated on 31/5/2020. 2020, right?
Yes.
2020. Yes. এইখিনি আকৌ নতুনকে লিখাচোন 2020 হা তাৰপিছত দিয়া an audit was it is stated by the petitioner that an audit was conducted in Kachar High School. He was in some other school.
No, Kasar, not Nehru High School, that Kasar High School initially. He was a
Yeah, but I'll just start again. লিখাচোন. The case of the petitioner is that he was initially appointed as assistant teacher of Nehru High School on 28/9/1988 and was transferred and posted as assistant teacher of Kachar High School on 26/9/1989.
Yes, sir. Yes, sir.
Thereafter, the State Selection Board recommended and the husband recommended in view of an order passed by this court, and the petitioner was promoted to the post of headmaster of Kachar High School by order dated 5/8/2017. Thereafter, the petitioner continued as the headmaster and he superannuated on 31/5/2020. Full stop. It is stated by the petitioner that her husband, it was her husband, huh? Husband superannuated on so and so. Thereafter, the petitioner states that her husband died on 26/3/2021 and a certificate was issued to that effect. Full stop. Para. Thereafter, an audit was conducted in the Kachar High School for the period 1/4/2014 to 30/5/2020. And therein, an objection was raised for an expenditure of rupees 6,42,550 incurred during the period when the husband of the petitioner was the headmaster of the said school. It is stated by the petitioner that the said amount of rupees 642,550 was in fact diverted from midday meal account to the development account as per the decision taken by the SMDC, School Management and Development Council, and that husband of the petitioner had no, full stop. It is also stated that the said amount was spent on renovation and repair work of the school. Para. After the superannuation of the husband of the petitioner, pension was allowed, and even after the death of the petitioner's husband, the petitioner was receiving the pension, but the gratuity amount of rupees 10,72,089 was not paid to her till date. It is stated by the petitioner that no non-liability certificate was not issued by the headmaster of the school, and as such, the authorities in the government could not release the gratuity amount. Para. For non-payment of the gratuity amount, the petitioner submitted a representation before respondent number 5, that is the principal. Respondent number 5 is the headmistress. That is the headmistress of Kachar High School, with a request to look into the matter and to release the gratuity amount. And the said representation was forwarded by respondent number 5 to respondent number 6. That is the director.
6 is the SMDC.
To respond number 6, that is the
SMDC, no. Directly respond number.
That should be respond number 7, madam. That was 7, madam. It was,
So the-
I think, typographical mistake. It was.
show me the forwarding letter.
Yes, 17, page 17,
Page
annex of 5.
17. Forwarded to the Assistant Director of Audit Assam. Respond number 7, that is Assistant Director of Audit Assam, to do the needful for the release of the gratuity amount. It is also stated by the petitioner that along with the said letter dated 13/4/2022, that is the forwarding letter, the resolution of the audit, the resolution of respond number 6, that is what audit?
SMDC, madam.
That is SMDC, Managing Committee. The resolution of the Managing Committee, approval, as well as utilization certificate for the entire money was also forwarded.
So in response to that, my lord, respond number 7 issued the letter to the headmistress stating that it is not a.
In response to the said letter, in response to the said forwarding letter, the headmistress wrote to the
No, my lord. Respond number 7 wrote to this, my lord, to the headmistress. That is Assistant Director of Audit.
yes, in response to that so and so, which page?
Page 18, your lord.
Page 18.
Annex of
Yes, the Assistant Director of Audit Assam wrote to the headmistress of Kachar High School So what is the, it is a school authority to take, with a direction that a school authority should take concrete steps for pursuing the matter
With the higher authority.
as per the direction of the higher authority. Full stop. It was also directed that the school authority should seek necessary guidance from the higher authority for settling the matter. Then what did the higher authority do?
Higher authority, my lord, they are required to, my lord, do this post facto approval.
And then an affidavit is filed.
By the headmistress.
Okay, then I'll continue at 2 then, right? Otherwise it's getting late.
Yes, your lord.
Okay.
May I leave?
You can leave. I'll just dictate this small part.
Here what I'm trying to point out.
Just take me to that non-liability part.
Yes, Worship, what happened in this case, audit objection was raised.
Huh.
Subsequently, what we did on 19, Annexure 3, Lordship may kindly come to Annexure 3, page 63 of my affidavit.
Page 63.
63 of my affidavit, yes.
Yes, 63, yes.
Yes, this is a letter written by the headmaster to the director,
Huh.
seeking for post facto approval of.
Oh, this is good. Where it is?
Yes, Lordship may kindly.
63 of
Huh.
the affidavit.
Lordship may kindly.
Page
see,
no, where is, oh, yes, yes, last
Yes,
paragraph, right?
Yes.
Okay.
Yes, Lordship may kindly see,
Hmm.
that it was written way back on 19/6/2021.
Mm.
Then thereafter, nothing came.
Hmm.
In the meantime, my friend approached his honorable court again, my lord,
Hmm.
on 31/10/2025,
Wait. When?
the last page of my affidavit.
Yeah,
Page
after that
68.
nothing happened, then he came to the High Court.
Yeah, he came to the High Court.
Oh, no, yes.
In the meantime,
Uh-huh.
then he came to the High Court. Thereafter, my lord, when we entered
But
the
what did
hearing,
the High Court do?
see.
Uh-huh.
See.
Now, what
Yes.
did the High Court do?
No, High Court didn't do anything. This is the case.
Oh, this is the
pending.
case. Yes.
On 31/10, again, my lord, we sent reminder. You
Hmm.
please do something needful in the regard. Nothing was forthcoming. Now, my lord, they have come up with an affidavit saying that, my lord, due to non-issuance of non-liability certificate and that non-settlement of objection,
Hmm.
they could not proceed with the matter.
Post facto.
Yes, and in somewhere, my lord, they have stated that they have written to the government in this regard. So until and unless that audit objection is made, well, we cannot issue that non-liability certificate.
So what I'll do is I'm thinking of directing the director
Yes.
to give that post ex facto
Yes.
in view of the facts.
Yes.
Okay, the respond number 3, that is the headmistress.
5 minutes.
Or respond number 5.
5.
Respond number 5, that is the headmistress of Kachar High School by affidavit, by an affidavit, had annexed a letter which she had addressed to the Director of Secondary Education Assam, intimated that to meet the audit objection, the Director of the Secondary Education may either allot fund of rupees 6,42,550 as spent in connection with construction work of the school, or to give post facto approval for diversion of the fund from midday meal account to the construction activities. However, the said exercise has not been done as yet. That is, there was no reply from the Director of Secondary Education Assam. Full stop para. However, in an affidavit filed by the said respondent, that is Director of Elementary Education, Director of Secondary, right? Secondary Education Assam, by way of an affidavit filed on 5/5/2006, had stated that the commission, where is that letter? This page number 75?
Your lordship, lordship kindly see at page 66 of the affidavit.
No, 75 is the letter.
Yes, letter written to the commissioner secretary. In paragraph also they have stated the commissioner secretary that they have issued page 69.
Page 69, yes?
Yes.
Paragraph?
Paragraph, last paragraph, your lordship may kindly see.
Paragraph, which paragraph?
Communication.
Roman 4.
Yes. Is pending due to objection and the estimator says that the same amount was spent in meter fund. In that letter, they have simply say that due to non-liability certificate, that is last paragraph. Because they cannot issue the non-liability certificate.
Stated that the headmistress of the school did not provide the audit settlement report along with non-liability certificate in respect of the husband of the petitioner, right?
Yes.
Husband of the petitioner. And as such, the said prayer could not be acceded to by the authorities concerned. As such, it is seen that the Director of Secondary Education and the headmistress of Kachar High School are trying to saddle the responsibility on each other. And in the process, the petitioner is suffering for non-payment of the gratuity amount. In view of the said facts and circumstances, it is therefore directed that the Director of Secondary Education should give the ex post facto sanction in view of the fact that there was no question of misappropriation done by the husband of the petitioner, since the said amount was used by the school in construction activity. Full stop. Further, it is directed that the headmistress, no, the school authorities, directed that the school authorities, upon receiving the ex post facto approval, may issue, shall issue the non-liability certificate in favor of the petitioner.
Husband of the petitioner.
In favor of the husband of the petitioner. And the resultant amount of the gratuity and the resultant gratuity amount of rupees 10 lakhs, so and so, 10 lakh.
72,000.
72,000. 089.
089.
Should be paid to the petitioner as the gratuity amount. Duly eligible to be received by the petitioner's husband. Oh no, by the petitioner. The entire exercise may be done within a period of 2 months from the date of receipt of the order. Petition is disposed of.
May I place your lordship? Matter relates to the release of the arrears salary as well as giving the national pensionary benefit of the petitioner.
Achha, last time something happened. Respond number 3 was supposed to file AO. And then instruction on the name also directed to be obtained. Okay, it is also made same should release to petitioner. Instructions and AO. Yes, Tabildar, you are there. affidavits are filed? No.
Sometime 2 weeks time may be granted, Lordship, because I have talked to the authorities. also.
Area salary, these are all not so rich.
Not Lordship,
uh,
he's
repeats it.
receiving everything, that area part of the Lordship, the associate professor part. So Lordship, where some calculation part is going on. So 2 weeks, Lordship, only notional benefit is there, she's claiming.
Okay, Mr. A.R. Tebildar, Learned Standing Counsel for Higher Education Department, submitted that although he took time to file affidavit on the last occasion,
Yes, Lordship.
but on genuine reasons he could not file, and as such has prayed for some time, as such has prayed for some more time,
Lordship.
full stop. Seeing the reasons given, this court allows the Learned Standing Counsel to file the affidavit within a period of 2 weeks.
2 weeks.
Place this matter on
After,
8th of June.
Lordship, can it be after 13th of June, on 14th?
On 14th is Sunday. You
Then-
come. 15th of June.
15th. Lordship.
15 June.
I'll ensure, Lordship.
Okay. And what about instructions? Same.
Same, Lordship.
It is also directed that the necessary instructions as sought for by the last order dated 2/6/2025 may also be incorporated in the said affidavit.
Obliged.
20. Yes, Mr. Khondokar.
Look,
Hmm.
look here,
Hmm.
petitioners number 1 to 20,
Hmm.
they are the parents of students, my lord, and others are local people, my lord.
Hmm.
What happened, my lord? How
What
they are-
happened here? What happened will come later. What about the pleadings here?
It is,
Exchange.
my lord, yes.
Complete.
The respondent number 2 also filed.
We have already filed our affidavit, my lord.
Hmm.
But here, my lord, their school is under rented premises, my lord. Here
So,
in
okay,
our-
let him complete then. This can be taken up for final hearing?
Yes.
Yes, okay. Yes, Mr. Khondokar.
Page 56,
Hmm.
this is the impugned order
Hmm.
by which, my lord, our school has been merged with a school. My lord, page 57 is the real original order.
So it is amalgamated.
Amalgam,
It is merged with some higher school.
other school,
57.
57, my lord, in
Is it kahan
pursuance
hua
of
nahi,
the
no?
government order so and so,
Is it
so and
kahan
so,
hua
so
nahi?
and so, the direct.
Wait. I have not finished reading. In pursuance of the government order so and so, the Director of Secondary Education, Assam, is pleased to issue the order of merger. Barai Alga High School with Hathingimari. So you were earlier in Barai Alga.
Boral Alga High Madrasa, now it was Boral Alga High School.
So it was
merged with
merged.
Hathingimari
Okay.
Seniors. My lord, one thing, as base school. My lord,
As base school.
as base school.
So base school will be Hathingimari.
Will be Hathingimari, but it is wrong. Our school itself is the base school because in nearby, within 5-6 kilometers, no high school is there.
Acha.
So when there is no high school, a basic school means an existing school. It will be Vansar, it may be Vansar school or government school, provincialization. It should be within 5 kilometers in case of high school.
So one high school in entire 5 kilometers area.
Only one.
Then it will be a base school.
It will be
What is the definition of base school? Provide.
in the act.
Okay, we will go into that. You first finished the
Then,
facts.
So, page 57 says, my lord, only as base school. No reason, nothing has been given why it is amalgamated. Nothing is there.
But which one is base school? How will you make out?
Page 43.
Huh?
That is the page 43. is the,
43.
provincialization order.
Huh.
Our school provincialized in the year 2021.
This order was in 24.
Page 43, my lord.
Acha, okay.
This is provincialization order
Of Alga.
of
Borai Alga.
Boral High School, my lord. Now, serial number 1.
Is identified as the base school.
Yes, my lord. The serial number 1, my lord.
Yes.
The Boraralga High Madrasa is identified as the basic school for this school.
For
So
this.
it itself is the basic school.
Same school.
Same school. But in order they can.
Wait. In provision of so and so 2018 and so and 2018, what governor will provincialize the services of teachers and non-teaching Oh, so and so with effect from the subject to the condition of their performance. Okay, then.
Then, my lord, paragraph 2, the land and building of the provincialized school have to be handed over. This is another thing, my lord. So, after fulfilling all the norms, including land, the school has been provincial is very recently in 2021. My school is itself is the basic school, but in the impugned order, they said basic school is Harshingimari Senior, my basic school.
But whether that is the case here, you see, in pursuance of so and so is pleased to issue the order of merger of Borai Alga with Hat Hingimari as base school.
They cannot.
Or it can be read the other way out. Or Alga High School will be the base school. No.
No, then, my lord, because they cannot merge it. That is why they have done something which cannot be done directly. They have done.
So you are against the merger?
Because in our student, our children, daughter, they are facing very hard problem, my lord, because no school is there.
That is the decision of the government.
Government, there is a rule also, my lord. Rule I am going to rule, my lord. Kindly.
Acha, what else you want to show from this petition? This is only the thing.
Basic school is my one is the basic school. So they are saying that basic school is the Harshingimari school. They cannot make it a basic school because that school is too away. That is, and from the provision, from the law, my lord, I am showing. My lord, kindly
So
come.
what? Education manual?
Education.
Yeah,
Kindly come to case. First of, my lord, I am showing, my lord, the definition of basic school. Case,
which act? 2018?
2017 Act.
17.
102.
Yes.
Basic school is there, my lord. Page 102. My lord.
Yes. Base school, yes.
Basic school means an existing provincialized or a venture educational institution identified for the purpose of provincialization of services of teachers and or tutors, as the case may be, within the radius of 1 kilometer in case of lower primary schools, within the radius of 3 kilometers in upper primary schools, within the radius of 5 kilometers in case of high school. So our school is high school here. So when there is no school within 5 kilometers, that it is marked as
base school. Okay.
That is why in the provincialization order itself says our school itself is the base
school.
So then, my lord, kindly come to section 12, that is page of the same act, page 119, 119.
Yes.
Section 12.
Amalgamation, merger.
Amalgamation, merger, and shifting or expansion of educational institutions, my lord. The 12.1. In appropriate cases, if there is already an existing educational institution nearby and the enrollment of the students do not justify for more than one institution in the same locality, or there are other sufficient reasons to do so, the state government, in the public interest and for reasons to be recorded in writing, may order for transfer, shifting of the institution and the incumbents of the institution from one place to another, or may order amalgamation or merger. So, my lord, the what act says, reasons, only the state government can do it. The government can do it with a reason to be in writing, my lord, in writing.
And reason can be enrollment of the students.
Any reason can be, but they have to give reason why they order merger.
Yes.
Passed. Now, last line, my lord, more existing, as per the Shiksha Kshetra scheme. So, scheme is there, so they have to follow the scheme. Without following the scheme, they cannot do. Now, my lord, I have annexed the scheme, that is page 20, original is page 34.
Wait, 1 second. I'm just looking into something. Wait, it came to my mind.
That
Wait, 1 second. I'm just looking into something. Wait. Yes, what then?
Uh,
Then
as-
scheme.
My lord, as Act says, as per Act, it should be done as per scheme.
Hmm.
Page 34, I have annexed the scheme.
But
Subject, my
wait,
lord, Shiksha Khetra scheme,
wait, Shiksha Khetra scheme was where?
page
Uh,
34.
No.
Oh,
In the act?
At
Uh-huh.
the page 119.
119. No, I went on to see whether the 2018 rules is applicable
No,
in.
it is 17.
No, in other case.
Oh.
Applicable in Bodoland Territorial Council. Acha, so 119.
119, section 12.
Yes.
Last
So
line,
as per
as per
Shiksha
Shiksha
Khetra
Khetra
scheme. Hmm.
So I have observed the scheme also. Page 34 of my read petition.
Yes,
This is
34.
the Shiksha Khetra scheme.
Hmm.
Now my lord come to serial number, clause number 3.
34. This is the scheme.
Scheme, Shiksha Khetra.
Shiksha Khetra. Scheme for amalgamation and merger.
Merger of different.
Okay.
That is the particular scheme. Now serial number 3, my lord. After careful consideration of all aspects and with a view to derive optimum services of the employees and other logistic support of the schools, it has been decided that the schools stipulated in same campus or in any nearby area shall be amalgamated, merged, and all the teachers shall be.
All the schools shall
So, scheme says, if the school, if there more than one or two schools in the same campus, it can be amalgamated. Our school is not the same campus.
or in nearby area.
Nearby area. That, my lord, nearby it is, we are saying our school is more than 5 kilometers. They are saying 2 kilometers. They are admitted 2 kilometers. But anyway, 2 kilometers is not nearby. My lord, then my lord, anyway, now kindly come to page 36, my lord. Of the same scheme, clause 5. There shall be one committee.
Clause 4.
Clause
5, yes, down below.
There shall be one committee of the block level and district level to find out the schools which are eligible for amalgamation or merger in view of the provision of RTA. So there is a committee. One is block level and is district level. Now page 37. First, my lord, the first committee, block level committee.
Then district level.
Chairman, district elementary education. So, my lord, two committees are there, page 37. Block level and district level. Then, my lord, clause 6. For a smooth implementation of the above scheme and for obtaining government approval, the following procedures shall be adopted by the authority concerned. It shall be adopted. So, number 1, my lord, block level committee shall identify such schools which are eligible for merger or amalgamation and shall send the list of such school with detailed particulars as per annexure so and so shall forward to the district level committee for examination. Then, my lord, 2, the
district level will examine the proposal as well again furnish their recommendation proposed to the director of secondary education.
Then director will send to the government.
Then director as the case may
Thereafter,
be, okay.
government will issue merger. In this case, my lord, directly the director issued order. He cannot. He bypassed the.
But the director is the government in secondary education level.
No, secretary is there.
Secretary is there.
Secretary is the government. But where is the two committee? They have bypassed. There is no recommendation. In the affidavit, they have stated, my lord, only as per report submitted by IS. IS cannot. Where is the two committee as per Shiksha? My lord, in their affidavit, my lord, kindly come to page 69, paragraph 4. Page 69, my lord.
Yes, I've got it.
That the answering deponent humbly begs to state that in this present petition, so and so, the Borarelga High School so and so has been merged with Hashingimari Senior District so and so, by office order number so and so, dated so and so, on the basis of report received from the inspector of schools.
That is also not contemplated.
My lord, they have not followed the procedure.
Infrastructure of the school is poor, as well as the school is
No,
eroded.
it will be examined by the committee. That is why committee is there. But the inspector has something. He has the personal interest. That is why he has directed in the report. So, my lord,
This is the case.
Provision of the act cannot be bypassed, my lord.
Okay, let's see what he says. That is your case.
My lord, that is case. They have, my committee has not, it has never been placed before the committee has never.
Yes, Mr. Sharma.
Here, my lord. In paragraph 4 of
Mm.
page 69, in our affidavit, it is highlighted that the
Yes.
infrastructure of Bagiar Alga High School is poor,
Mm.
as well as the school is eroded by river.
Mm.
Earlier school is eroded by river, and now the land of the school is situated in a private rented.
Yes.
So, my lord, it is a rented property, and as per
No, whatever it is, the main argument is that the procedure is not followed. There was no block level committee was placed before.
my lord, regarding
State level committee. Hmm?
regarding that, I have to take instruction. What policy has adopted?
Now I've already asked you. You said the affidavit is ready. Now no more instructions.
But
Instructions are in place.
yes, madam. But in our affidavit, it is not mentioned or it is not reflected.
Hmm.
So, my lord, to clarify that point, my lord, whether state level committee or district level committee has.
That is not reflected in your affidavit. Right.
In our affidavit, it is only
Silent, my lord. No,
only
Basis of
reflected and
report received from inspector. Inspector has
Yes.
got nothing to do with that.
yes.
and the school is 2 kilometers away. It is stated here, my lord. And nothing more was mentioned.
Passing orders. Okay. Heard Mr. A.K. Khandokar,
MR Khandar.
M.R. Khandokar, learned counsel for the petitioner.
My lord, may I submit, my lord? My lord, direction may be given to the director. They have already submitted one representation.
Hmm.
So representation may be disposed of.
Yeah, they will
They-
reject it. They will reject it by speaking
My
order.
my lord, no.
Okay. So what I'll do is follow the law.
Yes.
My lord.
Follow the law and then you march, you amalgamate, whatever. But in this case, it is not followed. Whose mobile? Hmm. Okay. M.R. Khandokar, learned counsel for the petitioner, and Mr. U. Sharma, learned counsel for
Secondary
respond
Education
number,
Department.
your higher education.
No, secondary
Secondary.
education
I
department.
get confused with secondary higher. So you are appearing for respond number 1 to District Commissioner Inspector.
No, district commissioner is there, my lord. I am for the respondent
Yes.
number 1, 2, and 4, my lord.
1, 2, and 4.
Yes.
And
District
Bormon, learned, yes, for respond number 3. By this application, filed under Article 226 of the Constitution of India, the petitioner has challenged the notification or what order? Petitioner has challenged the order dated. Where is that order?
2/3/2024.
Wait.
Yes, 57.
Wait, page? 2/3/2024, by which the Director of Secondary Education Assam by which the school, namely Borair Alga High School, BARAIR, Borair Alga ALGA High School, was merged, MERGED, merged with Hatingimari, HAT Singimari, SINGIMARI, Senior Secondary School, in the district of South Salmara Mankachar, under the Assam Education, start bracket, open bracket, Provincialization of Services of Teachers and Reorganization of Educational Institutions, close bracket, Act 2017, as amended in 2018, full stop. In the said order, it be stated here that in the said order, the Hingimari Senior Secondary School was declared as the base school. The case of the petitioner is that. No. The case of the petitioners, who are the parents of the students and local people. Parents who are the parents of the students studying in Algair, it is a school called? A school. And few local inhabitants is that the Borair Alga High School was established in the year 1980, and it is stated that the said school is the only high school in 5 kilometers area. Full stop. The petitioners further stated that Director of Secondary Education Assam, by order dated 4/1/2021, had provincialized the services of teaching and non-teaching staff of the said school as tutors under the Act of 2017. Is that hereinafter referred to as 2017 Act. It is also stated that said Borai Alga High School was earlier Borai Alga High Madrasa. What is that? Where? The said school, while the said school was running since the year 1980, the government of Assam in secondary education department had issued an office memorandum on 22/9/2016 under the Shiksha Khetra scheme for amalgamation and merger of different schools. And thereafter, the Director of Secondary Education Assam, by the impugned order dated 2/3/2024, had merged the said school with Hingimari Senior Secondary School as base school, as mentioned above. Aggrieved by the said merger, the petitioners, along with other local persons, filed a representation to the Secretary of the Government of Assam, Department of School Education, for cancellation of the impugned order issued by the Director of Secondary Education. But the said representation was not given any heed to by the respondent authorities. The learned counsel for the petitioner. Oh, no. Apart from that order, you had shown something. What was that? Oh, yes. Shiksha.
Page, my lord, page 36
Oh, yes, that.
and 37.
No, 43 you had shown something.
43 provincialization order. Where is my school itself is the school?
Shiksha Khetra is 36, 37, right?
36, 37. And
Yeah.
provincialization.
Learned counsel for the petitioner submits that by an earlier order dated 4th of January 2021, the school, namely Borai Alga High Madrasa, which has been turned to a general school, was made a base school. And the said school had all the necessary infrastructure as reflected in the said order dated 4th of January 2021. The learned counsel for the petitioner further submits that in the impugned order, the other school with which the alleged merger had taken place was considered as the base school, and the same, according to him, is not correct.
Madam, generally high school would be a base school, madam.
It is his contention that
Yes.
I mentioned. The learned counsel placed reliance on Section 12 of the 2017 Act, which provides for amalgamation and merger of schools. Full stop. It is provided in the said provision that if there is already an existing educational institution nearby, and the enrollment of students do not justify for more than one institution in the same locality, or there are other regions, the state government, in public interest and by recording regions in writing, or may order for amalgamation or merger of two or more existing institutions. Full stop. It is further provided in the said provision that the amalgamation or the merger or shifting, as the case may be, should be done as per Shiksha Kshetra scheme. And it is also stated that the said exercise be conducted in appropriate cases. Full stop. The learned counsel thereafter had placed the Shiksha Kshetra scheme by which it is provided that in cases of schools situated in the same campus or in nearby area, the same can be amalgamated or merged into one unit full stop. No, one unit by following the conditions mentioned in the said scheme. He thereafter placed clause 9 of the said scheme, which provides
Clause 5, madam.
clause 5, not
Five.
9.
Last, five,
Clause
5, 6, 5, 6. Page
Clause
36.
5, of the said scheme.
Page 36 and 37. 36 last paragraph.
5, to show that there has to be two committees. One block level committee and the other the district level committee. And the members to constitute the said committee are given thereunder. Full stop. He thereafter placed clause 6 of the said scheme, which provides that for merger or amalgamation, block level committee shall first identify schools which are eligible for the same and shall send a list of such schools with details to the district level committee for examination, and that thereafter the district level committee will examine the proposal and furnish the recommendation to the director of secondary education. If the school is under secondary education, or to the director of elementary education, if the school is under elementary education. And that thereafter, the director of secondary education or the director of elementary education, as the case may be, shall furnish the proposal to the government. And thereafter, the approval, after consultation with the finance department, would be given, and the merger will come into effect. Full stop. He submits that in the instant case, the said exercise was not gone into, and the director of secondary education has issued the impugn order dated 2/3/2024, merging the said school with the higher secondary school, senior secondary school. As such, he submits that the said merger was illegal and has prayed for setting aside. The learned counsel appearing for the higher education,
Secondary education department.
secondary education, submits where was that the inspector of school thing? Oh, yeah.
My lord, that is.
Submits.
page-
You are for response number 2, right?
Yes.
Submits that that Barai Alga High School was merged with Hatsingimari Senior Secondary School on the basis of the report received from the Inspector of Schools, South Salmara, in which it was stated that the infrastructure of the Borai Alga High School was poor, and also that the school was eroded by river, and the land of the school is situated on private rented land. Situated on private rented land. As stated in the affidavit in opposition, filed on 9/9/2025. Anyone else has filed affidavit? No, no?
No. Only headmaster is.
He as such submits that a region order was passed while taking the decision of merging the school with the other senior secondary school. And that it is the prerogative of the government to do in appropriate cases. Fair. In the impugned decision, impugned order, in the impugned order, it is seen that the Director of Secondary Education has passed the order of merger in pursuance to the government order instruction issued on 21/2/2024. However, it is not clear as to whether the procedure provided in 2017 Act was fulfilled. But it is seen in the affidavit filed by the respond number 2 that the inspector of school had taken the call and gave a report to the Director of Secondary Education, Assam. And as could be seen from the said affidavit filed by the Director of Secondary Education, that the inspector of school had also given the reason for the merger. And the reason was that infrastructure of the said school was poor, comma, school was eroded by river, and the school was situated in a private land. Full stop. It is provided under the Act that in cases where enrollment of the students do not justify for more than one institution in the same locality, or there are other regions, the state government, for regions in writing and in public interest, may order for amalgamation or merger of two existing institutions. In the said, in the said provision, that is section 12 of 2017 Act, it is also provided that the incumbents whose services has been provincialized in one of the school should be placed in the same rank and grade in the amalgamated school or in any other school. And further, the entire procedure is prescribed under the said Act. However, it is seen in the instant case that the issue of merger has not been placed before the block
Page 37.
level committee. But block level committee is only for elementary sector.
District level. District level.
But this is stated as elementary sector.
My lord, inspector of this school is there, that is district level. District level, madam. District level committee.
District Elementary Education Officer, where are you showing?
My lord, page 37, close C, my lord. The district level committee.
For 6th schedule area.
B, my lord, district B.
District level committee.
Here, inspector of school is member secretary.
Inspector of school is member secretary.
But chairman is additional deputy.
Number 3 is district elementary education officer. But here in the condition it is written.
It is
District
not
level
followed.
But whether the district level committee will themselves, because see, under 6, block level committee will identify and send it to district level.
Yes.
Then district level will examine and then send it to Dheri. But in
block level committee is in terms of elementary section only.
Block level is only elementary sector.
Yes.
Now here is a case where high school is amalgamated with senior secondary school.
Secondary, so district level.
So district level will itself not take up the proposal.
Yes.
Who will present the proposal? That is not reflected.
Point number 6, sub point 2, district level committee will examine the proposal as may be required and furnished.
But this cannot be read in solo. It has to be read along with one.
Plus 2, the district level committee will examine proposal.
Things are not clear. This is in case of elementary sector.
Elements.
I think this district, block, district, and even 6th schedule area is for elementary. What about high school?
No, my lord, IS is not for elementary. IS is inspector of school.
But in case of my lord, ME school or MV school, as with the high school, then this clause is applicable. But in case of high school and higher secondary school or senior secondary school, this my lord condition may not be applicable.
All the schools situated in the same campus shall be merged with the high school. If there is higher secondary school, senior secondary and higher secondary, what is the difference?
Senior secondary, high school, secondary department.
No,
senior secondary?
High school class 10 and senior secondary or secondary to up to 12, my lord.
So it
11 and
same.
12, 12 is senior secondary.
Falls under the secondary education. Class
But
9
what
to 12.
and elementary school is
1 to 6, 1 to
ME?
8. 1 to 8.
1 to 8.
1 to 8. And 9
Class
to
9
12,
to-
secondary.
Under secondary.
You were for 9 to 12,
Yes.
secondary.
My lord, what happens?
Wait, let me read. You are not clear, you have not placed the right provision. Higher secondary is different.
Higher secondary.
Yes, Mr. Sharma?
Yeah,
Higher secondary is different.
secondary, senior secondary are same, my lord. Higher secondary class
11, 12.
is 11
Only
and 12,
higher
yes.
different. Secondary education, high school, higher secondary, senior secondary, all are under secondary education. Class 9 to 12. After 12, my lord, it is higher education. My lord, what happens? The IS is supposed to place. He is a member secretary. So he is supposed to place before that.
The junior college, the assistant teachers and other staff, the employer in college, the staff veteran.
My lord, clause 6(2) is clear, my lord. The district level committee will examine the proposal as the case may be required and furnish their recommendation on proposed amalgamation merger to the director of secondary education if the highest school is under secondary education. So
If the
their senior school is under secondary.
Where is that 5 kilometer you have shown?
5 kilometer, my lord.
My lord, it is 7 kilometer for high secondary school and for 5 kilometer.
It is, my lord, in definition, my lord, definition of basic
Definition.
school. Definition of basic school, it is, my lord, page
102
page 102, my lord.
of chapter. Section 2 D.
102D, my lord. Definition.
Acha. Let the director of secondary education look into Mr. Sharma.
Yes.
Right. কি বলে কলো? No, block level na lage. Is placed before the district level committee. Who is supposed to examine the proposal and furnish their recommendation to the director of secondary education. It is, however, not clear from the scheme as to who would moot the proposal for merger of a high school with a senior secondary school. Whether it would be the district level committee or any other committee. Full stop. In the said scheme, the block level committee is provided for, but the said committee would only exercise in the elementary sector. In full stop. In the instant case, the merger is between the high school and the senior secondary school. Full stop. Further, in the definition of base school, it is provided under the Act of 2017 that the same would mean an existing provincialized or a venture educational institutions or any other such school is situated within the radius of 1 kilometer is within the radius of 5 kilometer, dear.
5 kilometers.
Is within the radius of 5 kilometer in case of high school or high madrasa, and within the radius of 7 kilometer in case of higher secondary school or junior colleges, the same would be the base school. In the instant case, the senior secondary school is considered as the base school.
Madam, regarding basic school, it is clearly stated, page 113, my lord.
113
Yes, my lord.
of the Act.
Yes, 2017 Act.
113.
Yes. Eligibility criteria, section 6B.
Where it is 36? 113.
Yes, 113, section 6B.
There is no section 3 here. Huh?
Under
Oh, section 3.
Yes.
Yes. 3.
Subsection 6B, my lord.
Subsection 6B. Yes.
If any provincialized school already exists within the aforesaid radius, the existing provincialized school shall be identified as basic school at the exclusion of a venture education institute within the said radius, provided that in case of 2 or more existing provincialized education institutions within the radius of an area as specified in clause A, the district scrutiny committee shall identify only one of such educational institution as basic school.
It is clear, my lord. The district scrutiny.
So generally, highest school may be treated
Will be
as
considered.
as basic school.
For that, my lord, Roman 3, section 6.
Let the director of higher education
Second,
consider all this. Huh? This senior secondary school is also provincialized.
It is also, yes, it is also in 2000.
Now further, likha further. Further, under subsection 6 of section 6 of the Act, it is provided that in case 2 or more provincialized institutions exist within the radius of the area as provided aforesaid, as provided above, the district scrutiny committee shall identify only one of such educational institution as the base school, considering the infrastructure and other amenities. Full stop. Para. Further, in the affidavit filed by the Director of Secondary Education, it is reflected that the merger, the issue of merger has been mooted by the Inspector of Schools on the reasons given therein. And the Director of Secondary Education had considered the same and issued the interim order. This dated 21/2/2024. What is this? That I wanted to find out. 21/2/2024. The order which is written in the first line of the impugn order, that is not the inspectors of schools recommendation.
Persons of government order.
Maybe inspector of schools recommendation. Yes, now school. Which according to the scheme is
Yes.
not correct in the eyes of law. Full stop. The inspector of schools is the member secretary of the district level committee, but the district level committee should comprise of other officials as well. Moreover, the impugn order was passed in pursuance to another government order dated 21/2/2024. Which is not placed by the counsels appearing for parties before this court. In view of the said facts and circumstances, it is therefore directed that the Director of Secondary Education would look into the entire aspect of the matter and, in compliance of the law laid down in 2017 Act as well as in the scheme, should pass the necessary order we will not set aside that order. Yes, Mr. Sharma. Let the director.
But my lord can, it is after setting aside, it can be referred to, my lord kindly.
And pass a fresh order. Should pass an order. Necessary order. For the interest of the schools and the students. In view of the same, the impugn order dated 2/3/2024 issued by the Director of Secondary Education Assam is hereby set aside and quashed. The Director of Secondary Education is directed to pass the necessary order according to law. No, no, lage. He might not also. Merger may not take place also. Right. Set aside. Petition is disposed of.
Maybe, my lord,
They will consider merger whether it will be. It is according to the law.
Instead of director, it may be to the secretary. He is the government authority. Because under the scheme, there is something, if any person is agree, secretary of the department. Since we are challenging the order of direct, it will be better to, my lord.
But a director ki kono last on entro. Director of Secondary Education or the secretary. Nalage, hikini ko katila. Or the secretary, that is secretary Nitina, to the government of Assam in Education Department.
my lord, in the order, in the scheme, it is written, the Director of Secondary Education or the Director of Elementary Education, as case may be, shall furnish proposal to the government in respect of department with post details and annexes for approval.
So actually, this is government. It is left to the government. Now he is saying that secretary is the
Secretary is the government.
secretary to the government of Assam Education
be better.
Department.
Education.
Should consider. Hekine eke thayu. Bas director or the secretary to the government of Assam in the
Yes.
Education Department. Let's see. If I make some changes, I'll do it
Yes.
later.
Yes.
But my.
Already merger
It is
could be
given-
happen, my lord.
No. it
First
may
of
be
all,
not-
things are not clear. Let him
Yes.
examine.
Yes,
Case is that, my lord.
that will
We
be
have-
better, my lord.
You
Let
land
the
also-
Director of Secretary, My lord, let the secretary be examine the matter and pass the appropriate order. Yes, after due verification, if it is clear that the already illegality is done, then they will pass the appropriate order.
Director or secretary, my lord, to the secretary. It will be better.
Otherwise, my lord, it will be create problem, my lord.
Oh, I'll think over. Okay, next.
I pay for little accommodation, Lordship. In this case, we have to file affidavit, Lordship. We have instructed the authority to provide instruction, Lordship.
Mr. K. Gogoi, learned standing counsel for Dibrugarh University. You submits that he requires some time to file the affidavit in opposition, which is not objected to by Miss Miss M. Nirola, appearing for the petitioner. Is this matter on
In the last of June, Lordship.
on 22nd of June?
Only one thing, Lordship, on the last fourth occasion, like council has.
We'll do. This time we'll do.
This time, Lordship,
We'll do.
kindly for the last.
Since a number of times adjournments were taken for filing affidavit, the learned counsel is as such directed to file the affidavit without fail by the next date.
Very good.
Yes, 25. Huh? Mr. Bhuya.
May I please, the lordship? Herein, your lordship, the petitioner, they were appointed as LP school teacher. And subsequently.
LP school teachers.
Yes. Subsequently, the schools of the petitioner have been upgraded as upper primary school. As upper primary school. But the service status of the petitioner have not been upgraded.
Service
They
status.
remained as assistant teacher of lower primary. In the meantime, the government have issued.
So affidavits are filed, but no, it's not filed. Yes, Mr. Saikya. Instructions are awaited on the last occasion, Miss Kuor. S. Kuor is not there today.
My lord, in this case, I am appearing, my lord. I need some time to file our affidavit, my lord.
Acha. Okay, you bring instructions also.
My lord. Otherwise, I have received the instruction, my lord. They are praying for the promotion to the post of headmaster, my lord. It is clear, my lord, and new amendment has.
Master.
Yes, my lord.
They want themselves to be upgraded to upper primary school.
That is also our prayer, your lordship, and in the meantime, the government has taken decision for promotion. And presently, we have.
Okay, let her file affidavit then.
My lord.
Heard Mr. R. Ali.
A.M. Khan.
A.M. Khan, learned counsel for the petitioner, and Miss S. Chutia, learned counsel for elementary education department. Elementary.
Elementary, my lord.
Miss Chutia, learned counsel, submits that she has the instructions with her and that she would like to incorporate the same in the affidavit and has prayed for some time. Prayer is allowed. Place this matter when?
After 2 weeks, my lord.
Place this matter on 15th of June.
My lord. Oh, bless me.
Yes, Mr. Datta.
In this case, my lord, it's a matter of prolonged suspension for almost 2 years. The last occasion it was submitted, the records have come, my lord. That's why the matter was fixed today, my lord. He's been under suspension, my lord, from 9/8/2024.
Records are here.
Records were.
Who was supposed to?
Here, my lord. Mr. Sharma was there, the counsel for the department, my lord, education department.
You, Sharma.
My lord.
Just now, the counsel who.
No. So you, I think the M. Sharma, my lord. Well, I think in the last week, it's recorded.
May I please your lordship? Lordship,
Yes.
I am appearing on the Disciplinary department, my lord. My lord, in this case, my record was so, my lord, can we, and accordingly, we have received the records, my lord. My lord, only difficulty is that
Placing the
my lord,
records will be difficult.
today is, due to this online. My lord,
Okay, when can you place the records then?
physical, any other day, my lord, will produce the record, my lord.
Day after tomorrow?
Day after tomorrow, madam.
Day
Yes.
after
My
tomorrow?
love. Yeah.
Okay.
Yes,
Okay.
ma'am.
On the prayer made by Miss
And Fukan.
Learned Counsel for
Elementary.
list this matter on day after tomorrow. List this matter on 27th of May.
Diploma. Engaged counsel is another court. That will
After
be
some time.
timely.
Tomato बोलना.
Yes, 28.
Hello?
I seek little accommodation because it was alluded to P. Datta, but he has to leave the court. Sometime may be granted, but
As prayed for by Mr. U. Sharma, learned standing counsel for
secondary education.
education, list this matter again on, when do you want? 4th of June.
Yes.
4th of June? Yes, Mr. Counsel? 4th of June is okay?
Lordship, this matter pertains to compensation and family pension, Lordship.
Hmm.
But here we are challenging a communication which your Lordship will find at page 55.
No, wait, let the other party, what is to be done as
No
regards,
affidavit has been filed.
no
No
affidavit.
affidavit.
They had taken time.
Yes, Lord. Can we let them file an affidavit? It is
Shall
paid.
file their affidavit in Oppo, all the respondents. But none of them, forget about filing affidavit, they are not there. Who appears? This is
Lordship, virtual mode.
Department of Agriculture, Mr. Saikia, who appears? Mr. Bhuya? So all agricultural university. Chishti.
Lordship,
Mr. SMT Chishti, you are there? For the respondents? Your voice is not audible. I cannot hear you. Your mic is off. Yes, you are there for agricultural.
Yes, I'm appearing for the department, but in this case, department has no role. It is a agricultural university. They are the main party.
Department of Agriculture is there as respond number 1.
Yes, I'm there, but it is a agricultural university. They are the main party.
Assam Agricultural University.
Yes,
Any
yes.
standing councils appointed
Yes,
by them?
yes. They have their own standing council.
So who is that? Any idea?
Last
Gogoi was supposed to appear.
Dixit
P-
Gogoi. D.
PN
Gogoi.
Goswami is there. PN Goswami is there. That Gogoi is also there.
So where are they today? Not there.
They're not here.
So we'll take it up some other day then.
Yes.
You can inform.
I can inform Lordship. That
Acha, Mr. Chishti, you
Yes.
inform to file their affidavit because
Yes.
they
I'll.
had yes, okay.
Yes.
They had taken time in December 25.
Yes.
So last opportunity. Let them
Yes.
file an affidavit.
Okay, I'll ask them. Yes.
Mr. Hurd, Mr. What do you write?
Khatuniar.
Akpi Khatuniar, learned counsel for the petitioner. It is seen in by order dated 8/12/2025. The respondents had taken time to file their affidavit in opposition. But when the matter is taken up today, the affidavits and affidavit in oppositions, it is found that affidavit in oppositions has not been filed. As such, the learned counsel, Mr. SMT Chishti appears for respondent number 1. And whose name do I put in here?
R.R. Gogoi, he was appearing on the last Thursday. R.R. Gogoi.
R.R. Gogoi.
Yes.
Mr. R.R. Gogoi. R.R. Gogoi.
Yes. In the first order, 8/12.
And Mr. R.R. Gogoi appears for respond number 225. Huh?
Yes.
When the matter is called up today, the affidavits have not been, it is found that the affidavits have not been filed. As such, the learned counsels for the respondents are given an opportunity to file the affidavits as a last chance. The list this matter on 15th of June,
Yes.
2026, by which date the learned counsel would file their affidavits.
can it be on 19th?
Okay, 19th of June.
What's up?
Mr. Chishti, you said
Yes.
by 19th of June.
Yes.
Yes.
Hello, excuse sorry, yeah, actually, in case of item number 28, there is an interim. That's
Oh, 28 time was taken, right?
Yes.
So interim order passed earlier shall continue until the next returnable date.
I'm sorry, when it's called for, I mean, like in another.
27, yes,
This matter regarding the non-payment of salary, my lord, 2000.
non-payment of salary. Respondents have not filed affidavit.
Yes, my lord, but from 2023, no salary has been paid, my lord. There are earlier litigations, my lord, and all this litigation has already been disposed of, my lord. So on those litigation, although my provincialization is service and under challenge, but it was not interfered with, my lord.
Your provincialization stands.
Stands, my lord.
Only that you are not paid.
Paid from 2023. Initially, my lord, there are 2 rounds of litigation challenging my provincialization along with the provincialization other, my lord. Initially, in the first round of litigations, my service, provincialization of my service has been stayed, but later on that was vacated. And during the second round of litigation,
Who challenged your provincialization order?
on Shahidul Islam, my lord.
Private individual.
Yes, my lord. Claiming himself to be a social study teacher, my lord. And my
Since one teacher for one school, for one subject.
One subject.
So he said that he should have been.
He should have been, because I am not a social study teacher, my lord. I am a language teacher studying Hindi, and my service was provincialized as a language teacher, being the senior most. And on that count, in the first round of litigations, initially my service was stayed, but
There
that
and
count,
vacated.
it was vacated, and thereafter I was paid. In that first round of litigations, this honorable court directed to verify the claim of the Shahidul Islam, and thereafter, in speaking order has been passed against him. That order was challenged before this honorable court. Again, he made me as a respondent, party respondent, although I am a senior most language teacher, and my service will be provincialized in any manner, my lord. And in that case also, initially my service has been stayed along with others, my lord. There are other respondents.
Then again vacated, now you are a provincialized teacher.
That case has been disposed of. A observation has been given that all the private respondents whose service has been provincialized shall be the outcome of the decisions taken up by the government during the course of verification of.
So elementary, anybody from elementary? Yes, online, anybody from elementary? So let elementary file their affidavit.
Only my prayer is, my lord, for that. Otherwise, this man will not survive. Now he have to doing, my lord, wage labor as on Sunday, my lord, to survive, my lord. That is the present condition.
But somebody has to be there.
No, I only prayed a short date, my lord. No, online, my lord.
Online also no one is there for elementary. Mr. A. Fukononam Didia. Heard Mr.
M.A.I. Hussain.
M.A.I. Hussain, learned counsel for the petitioner. It is seen earlier time was taken, no. By this application, no. Mr. A. Fukon, earlier order, no. I mean, yes, it is there. They had taken time earlier also.
Yes.
Yes, Mr. Shish.
Yes, here A Fukon, he's on legs. He's in
Achha, let A.
yes.
Fukon file his affidavit
Yes,
soon.
he will file. Yes.
Mr. A. Fukon appears for the elementary standing council elementary education. Appears for respondent number 125. No, 124. 124. Headmaster, you have to take notice. You had taken notice earlier.
My lord. You have taken up notice.
Oh, yes, service of notice upon respondent 5 is complete. Mr. A. Fukon prays for some time to file the affidavit in opposition. Prayer is allowed. List this matter on 10th of June.
Yes.
Tell Mr. A. Fukon.
Yes.
Higher education. Mr. Tobilder is there. Yes.
His case is under process right now. I just have gotten instruction of it.
Acha, some instruction is there.
Yes.
Cannot be full. I mean, half instruction. So what?
Yes, it's under process. Examination is for further. Government has already, secretary has already forwarded to the director, and it's under verification in the director level.
This is by deputy director to yes, deputy director.
Yes.
I'm here to inform you that this director had received government letter. It is remand issued by the Higher Education Department in a matter of promotion of Moniruddin Laskar. So they want some more time. This is the issue with regard to promotion of the petitioner.
So
So what instruction is forthcoming?
actually that processing, because the government has already instructed the director to process. So this after examining in shortly, if it is feasible, lordship, then he will be granted.
Probably the query was made by the deputy director, my lord, regarding bachelor degree is required or not for the post of senior assistant, my lord.
Senior?
For the post of senior assistant,
And
from
the-
junior assistant to senior assistant, my lord. Where the
These
bachelor
are not
degree-
teachers.
No, not
not
teachers.
Not teachers. Page 30 is the MP order.
And
That
the
query,
of
just
the
because of
college.
that query, my lord, the promotion was kept.
If he's entitled for promotion, he will get the promotion.
Yes, so
And why instruction is required?
some the process after examining whether he has all the requisite other qualifications also, not only that.
Because you can get relief from this side or that side.
Yes.
So he's trying his best from both.
No,
You can get relief from this side or that side. So you're trying for both. Otherwise, he has come to the court for relief.
yes, that's.
And now the process is on with you.
Then Lordship Secretary in the government has Lordship already cleared it and forwarded to the director.
Okay, Mr. Tohbildar, A.R. Tohbildar, Learned Counsel for the, what? Learned Standing Counsel for Higher Education Department has placed an instruction which says that the government is processing the matter and the outcome of the same. Yes, Mr. Chaudhary, government is processing, outcome will be delivered soon. Processing the matter and the outcome would soon be communicated to this court.
Only, sorry.
Yes.
Only question is going to retire mine. And since long time it is pending. Only they have to issue the order mine. Everything else has been done mine.
So he's retiring, get the instruction by next week.
Next week, 2 weeks.
No, my lord, now, your kindly see the date, how many days taken. I hope you also, my lord.
Yes, yes, I understand. But
Your person has been,
this
at
paper
the
has been
exact end of his service, mine.
No, what I was suggesting them is the petitioner has come to the court for relief. Now they can also go to them for relief. So if everything is done by them, well and good. We need not,
Also, my lord,
we will not do any exercise.
Idea also say that we are doing something to take that.
So you bring
Have
the
you seen the
telephonic instruction?
No, today only. This is 25 today's letter.
So 1 week's time, you get the instruction. Person is retiring.
Yes.
Right.
After 10 days, Lordship, because sometime may be recording.
In between.
Because of that, Lordship.
As such, outcome would be communicated to this court. As such, has prayed for some time. Prayer is allowed. List this matter on 5th of June. By which date the learned counsel would paste the necessary instruction
Yes, yes.
for final disposal of the matter.
Obliged.
Obliged.
Yes, yes, you will be heard. Time frame. Yes, time frame I'll give an opportunity to the hearing of the petitioners or representative. They have obtained. You have information. Who is there to say me that?
I think this is,
Are
if,
there?
yes, my lord. Item 31, my lord. I'm still awaiting instruction, my lord. I would like to file my affidavit here, my lord.
31. This is
31.
31. Acha, acha. Okay. Instructions are awaited and you'll file your affidavit.
My lord, I would like to file. Therefore, I have sought for instruction, my lord. Your lordship will give me 3 weeks time to file my affidavit, my lord.
Mm.
In fact, it is the last date. It was the notice of motion was issued, my lord.
Mr. B. Kaushik, learned standing counsel for
My lord, secondary education.
Secondary education, prays for some time to file his affidavit. Prayer is allowed. List this matter on 12th of June. Okay.
Grateful, my lord.
32, Mr. P.J. Fukon. Gauhati University.
My lord, I'll be on the aspect of the maintainability of this reason, my lord. The
Acha.
person appointed.
Now, if you fail in the maintainability, then you have to go into the merits of the case. You are ready?
My lord.
Yes. Okay. Let me hear the petitioner first.
Your Lordship, today
Hmm.
my senior has some personal difficulty due to which he couldn't the court,
Oh.
but he
Okay, we will take it up some other day then. We'll take it up on 8th of June.
also, Your Lordship, GO has to file affidavit since notices were issued
Hmm.
on 23, 26 itself. And
No, he will not file. He has his instructions, he said. He will not file affidavit, I don't think so. It's
Since
okay.
my lord, one academic register has been, my lord, selected and appointed.
Hmm.
That is under silence, but he has not been arrayed as party respondent. This is vital aspect.
Okay, let his senior come. Mr.
and Goswami.
N. Goswami, learned counsel for the petitioner submits that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter on when? 1st of June or too early? 8th of June.
My lord. Most of them.
52, 53, analogous matter. Yes.
The matter relates to release of the gratuity and
It was sent to mediation. Mediation failed.
yes, Lordship.
Hmm.
And the finance is supposed to file their affidavit. Lord.
We have filed.
Now file.
No.
Finance, Lord.
Higher education has filed. Finance department.
Finance.
No, for account is there. We have also filed our appraisal.
Account. Finance is required to file.
Yes,
Not-
Lord.
Yes, Mr. Chishti, you are not there. Whether finance is required to file the affidavit.
Police-
Hmm? What do you say? Finance is required to file? Or without the affidavit?
AG has filed, but copy has not been provided. to us.
26/8/25.
Without serving you copy, he cannot file.
Yes, Your Honor.
We have not received the copy. Lord.
Okay, you give your copies, right? Miss
Please, so, Your Lord.
P. Sohoria, learned counsel for the petitioner submits that she has not received the affidavit in opposition filed by the accountant general. As such, she prays for a copy of the same. Accordingly, the learned counsel appearing for the accountant general is directed to serve her a copy.
We have filed around 26/8/2025.
They must have lost. List this matter again on 10th of June.
Lordship, can it be, because in this up to 14, Lordship, lots of matters are fixed. Lordship, can it,
Which date?
after 14? Lordship?
After 14th. List this matter on 17th of June.
Yes. keep that.
Like-
Obliged.
54 is kind of.
May it please your lordships, my lord. May it please your lordships.
Make me, Lordship.
Wait,
Lord,
there
in
is a
the-
prayer from this side.
In the morning, yes, my lord. My senior, Mr. Chamuria, made a mention.
Hmm.
My lord, I could not give consent because there is some urgency in the matter, my lord.
Hmm.
The urgency is that I am pressing the IA. I want to press the IA because in the IA, my lord, I made a prayer to restrain the respondent number 5 and 6, not to take the admission of the student. My lord, what happened in this matter, my lord? The petitioner before your lordships is the owner and proprietor of a college in the name and style, College of Aeronautical Engineering, which is situated at Borjar, my lord.
Acha.
Now, what
Before going into the facts,
I'm sorry, my lord. I'm sorry.
before going into the facts, I think they have something to say. What?
Lordship, we would like to file the affidavit in IA.
You are appearing for Dr. A. Chamua?
No,
No.
I am appearing for the personal respondent. There is respondent number
Hmm.
5 and 6. My senior is Mr. Samaria, who mentioned the matter in the mention our.
Mr. Chamaria, I think he is associated with
Chamaria, yes.
Chamaria, my lord.
Lordship, we'd like to file the affidavit in respect of this IA within 1 week, Lordship, because it is, I send it for signing, Lordship. The respondent number 5 and 6 stay there in Odisha, Lordship.
So they have sent it for signing. Let us wait for a week.
Lordship, Lordship.
My lord, fine, my lord, I don't have any problem. My only anxiety is that because this is with regard to shifting of the entire college from Borja to Orissa. If they, my lord, get the students admitted at Orissa, and if finally this court decides that this shifting is erroneous or wrong, then the students will be in difficulty, my lord. So that's the reason why, my lord, this IA is for. Because the
Shifting
entire
from Borja to Orissa.
yes, they have shifted. Milord, there are some developments in there are some facts, Milord. Pursuant to those facts, they have shifted the college from Borja because it was one of a kind college in the entire Northeast, the Aeronautical Engineering College. It was shifted from Borja to Orissa. If they have already started the admission of the students. If they get the students admitted and they're at Odisha, then there will be problem for the students, Milord. Otherwise, because
So what
if
is this IA for? Why have you filed the IA?
Milord, IA, if your lordships, my prayer is
There's a lot of echo going on.
yes, someone I think switch on the
We
audio.
will take it up after 2-3 days, okay?
Lordship.
My lord,
1 week's time.
Friday.
1 week's time, we'll file our affidavit, Lordship, of affidavit.
Affidavit in the IA.
IA, Lordship.
Acha.
If
And we have
not,
already filed the affidavit in opposition in the main writ petition where some agreement is there, and the petitioner himself shifted his all rights to the respondents, Lordship.
my lord, I'll
No,
address your lordships.
what your learned friend is saying is that if the students are enrolled and all, they are admitted, then there will be difficulty with the student if
Yes,
this court
that
holds that the shifting is wrong.
Lordship, that's why we will like to file our affidavit.
So we will have to expedite the matter.
Lordship, yes, Lordship.
Yes,
So you file it, you
my lord, can it be on
This is
Friday, my lord?
can it
Can
be
it-
on Friday? What he is
Friday some
asking.
difficulties is there, Lordship. It is there, Lordship. That's right, Lordship.
So Monday then,
Yes.
Mr. Das.
Monday, fine, my lord.
Okay. Your
Fine, my
Mr.
lord. Monday.
MM Zaman, Lordship.
MM Zaman, learned counsel for the respondent number for the respondent
4 and
for
5.
the for respond number 4 and 5
4 and 5.
submits that he
5 and 6, Lordship.
for
5 and 6.
submits that he requires some time to file the affidavit in opposition. Prayer is allowed. List this matter on 1st of June 2026.
Fine, my lord. Much obliged, my lord. Highly obliged.
Heard Mr. H.K. Dasa
Yes.
for the petition.
Much obliged. Deeply obliged.
Ital ke nahi, huh? Item 6, who is appearing for item 6?
Yes, my lord. May I
Mr.
please?
C. Yes.
My lord, that regarding my lord the pensionary benefit, my lord, the mule issue of the case, my lord, whether petitioner is entitled to the pension in the old pension scheme or the new pension scheme. Initially, petitioner was, my lord, is a stipendiary teacher. After the Monohar committee, petitioners, my lord, he was adjusted. Page 21 is the order, my lord.
But stipendary teachers are all allowed the old pension scheme.
Yes, my lord. That's why, my lord, matter is required to be examined, my lord. The notice of motion may be issued, my lord, because he is prior to 1 to 2005. Because prior to 1 to
2005, yes. Old
prior
pension scheme.
Yes, my lord.
Okay,
That's
we will
why.
issue notice.
Yes, my lord. That is this.
Heard Mr. C. Goswami, learned counsel for the petitioner. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a direction to the respondent authorities to pay her pension under the Assam Service Pension Rules 1969. And to adjust the amount deducted towards the new pension scheme and to allow her to draw the regular pension. Issue notice. Mr. A. Fukon, learned standing counsel, elementary education, appears for respondent number 1, 2, 4, 1 to 4. And 6 also, I think. Block Elementary Education Officer, Lokhimpur. Yes, Mr. Chishti? 1, 2, 4, and 6.
Yes.
1 to 4 and 6. And then per pension, Mr. P. Saikia, Standing Counsel for Pension and Public Grievance. Huh? Oh, GA. A government advocate appears for respond number 3. Deputy Inspector of School, who will? You will appear.
Yes, yes, government will appear. Elementary, standing council elementary. A Fukon will appear.
A Fukon are 5-2 didiba. Yes. Extra copies be furnished to the petitioner. Extra copies be furnished by the petitioner within 2 days from today. Please this matter. When do you want, Mr. Goswami?
Just after 2 weeks or well, after 4 weeks, because they have to
This
file it.
matter on
After 4 weeks.
24th of June.
Yes.
Yes, Mr. Fukon,
Yes.
I have dictated that you are there.
Deeply obliged.
Yes.
Obliged.
This is the pension matter, my lord. So the last 2 days, my lord, time was granted to them to file the affidavit, my lord. Initially on 31/3/2026, my lord, and then, my lord, 29/4, my lord. Affidavit is yet to be
Yes,
filed.
the respondent should definitely file their affidavit by next date. So definitely went for a 6.
Yes.
Where are those people now? Who were there? S. Chutia?
Chutia was there.
Miss Chutia, you were there online, now you are missing. Yes, Mr. Chishti.
Yes, yes.
Where is Miss Chutia?
So,
She had undertaken.
Item 34, I am appearing, my lord. That affidavit is sent for vetting, my lord. Kindly grant 1 week time.
Item which you said?
34.
Yes, you are for elementary.
Yes, my lord.
Okay, you file your affidavit by 1 week's time.
My lord.
You had taken time today. You were sure to file it.
My lord, yes, sent for vetting, my lord.
I think last occasion, the same submission was made, it's been sent for vetting.
Huh?
Last occasion, perhaps it was made, I.
Yes, Chutia has prepared this affidavit, my lord.
Yes, Mr.
G.
Your name?
Pegum.
G. Pegu, learned standing
Standing
counsel
counsel.
for elementary education.
Yes, my lord.
Elementary education prays for only a week's time to file the affidavit, and he submits that he had already prepared the same and had sent for vetting. As such, time is granted. List this matter on 3rd of June, by which date the learned counsel would file the affidavit.
Obliged, my lord.
Mr. Hetu Didiba M. Datta, learned senior counsel, assisted by P.
Roy.
Goel.
P. Roy.
Roy. P. Roy, huh? Present for petitioner. 35, contempt case.
Hey, please, Your Lordship. Lordship, decline to convey the file, so we are no more engaged in this matter. Lordship. Lordship, we are no more engaged in this matter, Lordship.
You are no more engaged in the matter.
Yes, Lordship. Decline to convey the.
So you are withdrawing your names.
Yes, Lordship.
So you have to make an application to the registry. Right. Make an application to the registry. Okay. Miss
H.K. Sumi.
H.K. Sumi, learned counsel, appearing for the petitioner, has apprised this court that the counsels who had filed wakalatnama for the petitioner has withdrawn from the said case, and as such, she submits that she will make the necessary application before the registry of this court. Prayer is allowed. List this matter after 2 weeks.
Item 46.
Dr. P.K. Goswami? Yes, 36, none appears on call on.
I am appearing here.
Lordship.
36.
You're for respondent. But what about petitioner? Who is Dr. P.K. Goswami? And A. Burman?
Last occasion also.
None appeared. But it is, but the region was some flash flood. Rain was on.
Yes.
But Dr. P.K. Goswami appeared in the month of December 23.
Lordship, here my instruction is that we have already sent a proposal to the demand side. So Lordship may kindly fix it after a week. I'll get up to the instruction whether that payment was made or not.
But then the problem is petitioner side is not there.
Oh, yes, yes. Then Lordship may kindly take it up after 2 weeks or 3 weeks.
None appears for the petitioner on call. Mr. SMT Chistry appears for the respondents and Miss Ardeka for respond number 4. For the ends of justice, list this matter again on 17th of June. Yes, Mr. Sharma.
Next.
Contempt case.
Contempt case.
Oh, against the Director of Secondary Education.
In Gaji Rahman, we have issued a compliance order. Lordship may kindly fix it on Wednesday so that I can hand it over to the court on Wednesday.
There is
Yes.
already compliance.
Yes.
As prayed for by Mr. SMT Chistry, learned counsel for the contemner, list this matter on
Wednesday.
Wednesday is 27th.
Yes, yes. Obliged.
Lord, in this case, respond to 3 years. Already submitted their affidavit, Lord. So, but rule is already issued in this matter. So, it may be fixed for final hearing in the month of July, Lord.
Pleadings are complete.
Meetings, we are supposed to give the reply. By that time, we'll submit our reply if required.
Mr. D. Das, learned counsel for the petitioner submits that the pleadings in the instant case is complete and he may file an reply affidavit
To the affidavit filed by the respondent number 3 and respondent number 4.
to the affidavit filed by respondent number 3 and 4 if required.
Yes.
List this matter on
21st of July, Lord.
such a long date.
No, for hearing, final hearing, or I'm insisting before vacation also, on.
List this matter on 24th of June or 17th of June.
So, can it be on a hearing day, Lord?
18th of June.
18th of June.
18th of June. Yes, Mr. Bergnia. Mr. Chishti, you are there for
I am appearing, Your Lordship, for item number 38.
yes. 39. 38 is no, not there.
Already gone.
Yes.
No,
Ah.
my lord, affidavit is coming, and we will file our affidavit tomorrow, my lord. So, one day
Kindly
maybe-
see the order dated 16/6/2023, 2 months. This way, that way, they are taking time.
Tomorrow they will file.
Tomorrow we are filing this
Lordship,
affidavit, my lord.
Earlier occasion said my case was recommended for provincialization. Initially, it was placed, that again returned to the inspector of school. The district committee placed my case and recommended. Then they are sent to the government. Government again returned to the director. That is going on. What affidavit is required? Lordship, only to comply the direction.
No, my lord, as
Provincialization.
per last order, my lord,
That this way taking
honorable
time.
court has,
Certain developments
directed
have
us to
taken
file the
place.
affidavit, so affidavit is.
Kindly see,
Sir,
they have
one day
recommended on
so that we can
23
find our
year
affidavit
letter.
tomorrow.
13
They're reasonable enough. One day, what they want. Day after tomorrow, we will take it up.
Lordship.
Okay.
On
Mr. U. Sharma, learned counsel
they have to promote-
for respond number 2,
Yes, madam.
submits that he will file the affidavit tomorrow and has prayed the matter may be taken up on
Friday.
Friday.
Yes.
That is on 29th. On Friday. List the matter on 29th. Prayer is allowed. List this matter on 29th.
My lord, I pray for the adjournment on behalf of KV Padak, my lord. This conducting counsel, KV Padak is out of station. I pray for an adjournment on his behalf.
Okay. Miss T. Wapangla, learned counsel for the petitioner, prays for a submits that an adjournment may be granted in the instant case. Prayer is allowed. List this matter when?
After a week, my lord.
List this matter on 5th of June.
And there is an interim in. 30 days.
Interim order passed earlier. An interim order passed earlier shall continue till the next returnable date. Mr. Bharadwaj, yes. 42,
If I kindly pay the last order.
last order is paucity of time. Which order? 7-4. The compliance report was supposed to be placed, Mr. Sharma. But last time, Mr. P.K. Bora appeared. P.K. Bora appeared. Mr.
Yes,
Bora?
Lordship PK Bora, he has some personal difficulty. He is out of station for today. Lordship, may kindly fix it on Friday or next Monday, Lordship.
Because I think he has the compliance report.
Yes. He's today due to his some personal difficulty. He is not here, Lordship.
Okay. It is stated at the bar that Mr. P.K. Bora has personal difficulty in attending the court today and has prayed for some time. Prayer is allowed. List this matter on 1st of June.
Please, Your Lordship, my learned senior counsel is absent from the court today. He is absent from the court. So may I humbly pray to fix the matter on any other day?
Even affidavit in reply you were supposed to file.
We have actually filed an affidavit, but I'm not sure.
You have filed. Okay. Mr.
I'm on behalf of JMA, Mr. KG Chaudhary.
KG Sajdev
Chaudhary.
Learned counsel for the petitioner submits that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter when?
Anytime next week or on June.
List this matter on
11th
11th of June.
Your Lordship.
May I please?
Yes.
Also, item 44, we have instruction not to press.
Contempt case.
Contempt.
Instruction was supposed to be placed by elementary education.
Yes. Lordship, may kindly fix it on Wednesday, Lordship. This Wednesday.
Not to press, Lordship.
Not to press.
You
You're
Or not.
withdrawing.
Oh, yes.
Why you
I think it is complied.
Might be complied.
So
It
relief.
is, yes, it is complied. But that
Yes.
instruction we have.
Mr. M.K. Hussain, learned counsel for the petitioner submits that he has instructions to withdraw the matter.
Yes.
Prayer is allowed. The matter is closed as withdrawn.
I am for the sole respondent. That may be recorded, Lordship. For
Mr.
the sole
Assam
respondent.
history for
The sole respondent. Yes.
For the sole
Applied.
respondent. Mr. M.K. Hussain again. Here also complied.
No, Lordship, they have filed the affidavit, but the affidavit it does not reflect that the order is substantially complied, Lordship.
Yes, Mr. Sharma.
Yes, madam. Madam, here, here it is stated that Director Secondary Education Assam by letter number so and so was requested to fix the internship seniority on the basis of scale of pay of the two incumbents, and after fixation of seniority, the appointing authority to draft the gradation list accordingly.
Seniority will be based on payment of the pay grade.
Seniority on the basis of scale of pay minor.
So that will not clinch the issue.
Lordship, this honorable court directed the secretary, Lordship, to decide what should be the basis for deciding the seniority. The secretary, after hearing and perusing all documents, decided that seniority should be decided on the basis of scale of pay between these two.
Is this permissible?
Yes, my lord. As because, my lord, the petitioner and the my lord respondent number 6 of the writ petition was present in the hearing, and after hearing, my lord, all the documents were examined, and after thereafter, my lord, it is decided that seniority will be fixed on the basis of pay scale of pay of the incumbents, and accordingly.
So you have
secretary-
objections.
I have not, but gradation list subsequently, after fixing this seniority, gradation list was required to be prepared within 3 months, Lordship. That has not been done as of now.
They will prepare the gradation list. You will have an opportunity to object also, right? So I can close this matter on the basis of this.
It may be kept open. We will approach the director, Lordship, for prepare, Lordship.
Not
So,
required.
with
They will
Lordship,
definitely, after
can-
fixing the interest seniority, they will, of course, issue the gradation list. Otherwise, what is the purpose of?
This is not for Lordship, for
And
the purpose.
secretary, moreover, secretary, my lord, in his letter, it's stated that appointing authorities to draft the gradation list accordingly.
So they will draft and they will issue.
Yes.
Actually, this issue was just confined to holding the charge of principal, Lordship, not for regular gradation.
The in charge principle.
In charge
Yes.
principal. And the incumbent is going to retire, Lordship. He is now 58 some plus, Lordship.
But
And-
it will come on the basis of seniority, my lord, and the seniority.
So what was the direction by the
pay-
single judge?
By the single judge, direction was that the secretary should decide what should be the basis and thereafter prepare the gradation list.
And publish it. Where is that order? Show me.
Lordship. Kindly have a look at page page 10, Lordship, paragraph 7 of the direction, Lordship, of my petition, Lordship.
No, where is the order?
That is what.
Page 10.
Page 10 is the authority part, direction part, Lordship.
Huh.
Page 10.
Secretary is directed to take a decision as a basis for making the seniority list. He should also take a decision as to what would be the basis for making the seniority between parties. Thereafter, the seniority position and of respondent and petitioner should be reflected in the gradation list to be so made. The exercise should be conducted by the secretary after consulting the records. Opportunity of hearing should become. It's okay. Okay. It did not say that gradation has to be made and published. It has to be made. In fact, your thing is granted.
Lordship, entire exercise process should be concluded within a period of 3 months. Entire process, Lordship.
And gradation list to be so made should be reflected, and the petitioner should be reflected in the gradation list to be so made. So it is not said that you publish your gradation list immediately after that.
Lordship, actually, this issue is confined to that seniority for holding. If this matter remains hanging, then I will get nothing, Lordship. And that was the consenting order, Lordship, by both the parties, Lordship. Secretary decided.
So now they have fixed the basis for fixing the seniority on the basis of pay, whatever grade.
Pay.
And then it is on that the gradation list will be published soon. Let us close this contempt.
Lordship may kept it open. I will obtain extraction. What is the latest position, Lordship?
This is the instruction. Don't worry.
Otherwise, Lordship, they will never do, Lordship. They have this
Execute
order.
this order, I'll direct them to issue the gradation list.
That can be done, Lordship.
Okay.
That can be done, Lordship. That can be, that will.
Okay. Heard Mr. A.K. Hussain, M.K. Hussain,
Lordship.
learned counsel for the petitioner, and Mr. U. Sharma, learned counsel for respondent number,
Sole respondent.
sole respondent. By this application, the petitioner has, by this application, filed under section 11 and 12 of the Contempt of Court Act, 1971, read with Article 215 of the Constitution of India, the petitioner has raised willful and deliberate violation of the order dated, have alleged willful and deliberate violation of the order dated 8/4/2025, passed in writ petition number 3456/2022. By the said order dated 8/4/2025, this court had given a direction to the Secretary to the Government of Assam Education Department to take a decision as to the basis for making the seniority list of the incumbents. The said order was passed on consent of all the parties. The learned single judge further directed that a decision should be taken by the Secretary to the Government of Assam Education Department as to what should be the basis for making the interstate seniority between the parties. With the further direction that respondent number 6, with the further direction that the seniority position of respondent number 6 and the petitioner of the said petition should be reflected in the gradation list to be so made. And the exercise was directed to be conducted within a period of 3 months from the date of the receipt of the order. Full stop. It was also directed that while taking the decision, an opportunity of hearing to the petitioner should be given. Mr. U. Sharma, give me that instruction.
Yes.
Mr. U Sharma.
Part of the affidavit.
Oh, acha.
Yes.
Where is that? Page number?
Page 26.
Mr. U Sharma, appearing for the sole respondent, has placed a communication. Where is 26? There's no 26 here. Wait. The affidavit is in the front or what? Placed an instruction.
Last page.
Received from the Secretary to the Government of Assam, by which it was intimated that in compliance of the order mentioned above, a hearing was conducted on 17/7/2025, wherein the petitioner and the respondent was present, and after hearing the incumbents and on careful perusal of the documents submitted, a decision was taken that seniority will be fixed on the basis of scale of pay of the incumbents. It is also communicated that after fixing the seniority on the basis thereof, a request was made to the Director of Secondary Education to prepare the gradation list. Full stop, para. As such, it is seen that the order has been almost complied with, to the effect that hearing was conducted and the petitioner and the respondent participated. And on examination of documents, seniority was considered to be fixed on the basis of scale of pay of all the incumbents.
Both the
Of the incumbents.
both the income.
It is also noticed that request is made to the Director of Secondary Education to draft the gradation list on the basis thereof. In the order dated 8/4/2025, it was directed that after the seniority position is settled between respondent and the petitioner, the names of both the party should be reflected in the gradation list. To be so made. It is therefore seen that the order has been complied with by the authorities concerned. Except the part of preparing the gradation list. As such, it is directed that the Director of Secondary Education, Assam, should prepare the gradation list and publish it within a period of, again, this will be an order, right? As reflected, within a period of, as reflected in the compliance order. Will prepare and publish the gradation list as reflected in the order. This contempt case is closed accordingly. Yes, Mr. Mohanta.
Ladyship, this matter has been placed before your ladyship because of the office note dated 21/5 may be perused till it.
Yes.
Here, on the last occasion, our affidavit in rejoinder affidavit was not on record. Subsequently, it has been placed on record and marked as flag B. And one more noting has been done with regard to R3. if your ladyship sees order dated 23/4 in the office note,
R3 is a private respondent.
also, they are NIOS, National Institute of Open Schooling. Private, not private.
Not
National
private.
Institute National Institute of Open Schooling. So in this case,
R3,
R3.
National Institute of Open Schooling.
Yes, Your Honor.
So who will receive the notice?
That
Uttar Pradesh. Have you sent the notice? Have you
that
taken
notice has not
steps?
been issued.
Huh?
Notice has not been issued.
Oh, notice has not been
Yes,
issued.
as per the office note, it can be
Hmm.
understood. Moreover, no order for issuance of notice upon R3. Office note dated 21/5, 23/4, 26.
They are required otherwise. Required.
Yes, all this, they are only a compliance party. We have referred to a judgment where they had the authority, they were conducting the test. It's my learned friend.
Okay, let me issue notice to respond number 3. Mr. K.
My lord,
Hmm.
in this regard, respondent number 3 may not be required.
So that is what we are deliberating on. We will issue notice to respond number 3. What are you saying?
May not be required, Lordship.
Or may not be required, you say.
They will say, because we are relying on the.
It is for the petitioner
Yes.
to say. Heard Mr. K.M. Monto,
Yes, sir.
learned counsel for the petitioner. It is seen that the other parties are represented.
Yes, they filed their plea.
It is seen that the respondents are represented and they have filed their affidavits also.
Yes, sir.
However, learned counsel for the petitioner submits that respondent number 3 is not served with the notice and a prayer is made for, respondent number 3 is not represented, represented, and a prayer is made for issuing notice to the said party. In the facts and circumstances, it is seen that their representation is required, and as such, issue notice to respondent number 3, petitioner to take steps for issuance of notice upon the said respondent by speed post with AD or by usual process. List this matter on 22nd of June 2026. Interim order passed earlier shall continue
Can
until
it be
the
on
next.
18th of June?
18th of June.
Yes, sir.
18th of June, Kora. Interim order passed earlier shall continue until the next return of the date. 47. Okay, last year I was. Yes.
Lordship, it's regarding service upon respondent number 5, Lordship.
Hmm.
We were directed to take dusty service, Lordship. Accordingly, we have taken dusty service and I have filed an affidavit as because they
So his service is complete.
service is complete.
Lordship, I am appearing for the respondent number 5. We have,
You will file your affidavit or no?
we need little time.
Rejoinder affidavit you are supposed to file, no?
Lordship,
Petitioner?
we have already prepared it. We will file it by tomorrow or today itself. Okay. For filing.
Yes. Mr. P. Khatunier, learned counsel for petitioner submits that respondent number 5 is served with the notice and that he has filed the affidavit regarding the service by Dusty. Further, it is also noticed that Miss
P. Devi.
P. Devi appears for respondent number 5. However, Miss P. Devi makes a prayer that she may be allowed some time to file the affidavit in opposition in the instant case. Also, Mr. P. Khatunier submits that he would also like to file an affidavit in reply and has prayed for time. Prayers are allowed. List this matter on. Suggest on a date. List this matter
We will
on.
be filing our affidavit by tomorrow itself, Lordship.
Okay, list this matter on 19th of June.
19th. Open. Lordship, there's an interim that may be continued. Lordship.
Interim order passed earlier shall continue until the next returnable date.
Much on.
So, like, পাঠখন হতো আছে interim order আছিল নে? এখন পাঠ আছে। One second. Ask. Yes, Kondokar?
May it please, Your Lordship.
Yes.
Well,
Yes.
item 56, my lord, from our end, my lord, we have already updated the details of the petitioner for getting the arrears salary in the Fin portal, matlab, in Fin Assam portal. Now, perhaps, my lord, it will require some more time, my lord, for getting into reaching his account, my lord. So, therefore, I would pray, my lord, let this matter be taken up after 2 weeks.
Oh, otherwise his relief is granted.
Here, my lord, here the direction was to provincial to dispose his appeal, and the appeal was disposed in his favor, and thereafter, my lord, consequential steps has been taken for provincialization. Now, in pursuance of that provincialization, now he'd be entitled for the arrears salary. And now we have taken steps for release of the arrears salary. Now there is a change in the system where the details of the employees have to be updated in the Assam Fin portal, and that is being done now, my lord. Now we are for the further steps for compliance, we would require some more time, my lord.
Provincialization is done.
Yes, provincialization order is issued, but however, the petitioner by the time he was provincialized, he is retired, so he will be now just entitled to the salary.
Okay. Mr. B. Kaushik, learned counsel for the respondent.
Sole respondent.
For the sole respondent, submits that the necessary exercises in compliance to the judgment and order alleged of non-compliance is done, and that he requires some further time to place the up-to-date status. Prayer is allowed. List this matter on 11th of June, 2026.
Grateful, madam.
For the petitioner present.
Grateful, madam.
57. In 57, my lord.
57, my lord, I am praying for an accommodation on behalf of Mr. P.K. Bora, my lord. He is not there today.
My lord, there is an order to file.
Proposal for creation of post in the portal concerned. Director shall, before the next, file an affidavit and therein manner in which the direction pass was being processed. So,
My lord, kindly peruse the order.
no, it's okay. Director was before file an affidavit. Direction passed was supposed to be complied with by the director. Now that PK Deka is PK Bora. We'll pick it up next week.
Next week, anything, my lord.
Okay. Mr. B. Kaushik, learned standing counsel, or learned counsel, makes a prayer on behalf of Mr. P.K. Bora for a short accommodation of P.K. Bora for taking up the matter on a later date. Prayer is allowed. List this matter on 1st of June. There are so many matters. 3rd of June.
Grateful,
3rd of
madam.
June, Mr. Kaushik.
Yes, madam. I'll inform. Grateful, madam.
Lordship, here in this matter, service has already been completed, madam. There is already a direction to list this matter for admission on 11/2. So the matter may come for admission, madam.
No affidavit has been received by this section till date.
Yes, my lord, because
Affidavit was supposed to be filed by the respondents.
yes. Notice has been issued, my lord, long back, madam, 28/8/2020. Till then, yet.
But there is one
Lordship,
affidavit, it seems. Yes.
Lordship, our affidavit is on waiting, your lordship.
Achha. Miss H. Teramping, learned counsel, learned
Secondary
standing
education.
counsel for secondary education submits that the affidavit is prepared and is sent for vetting, and as such, some time is prayed for. Prayer is allowed. List this matter on
Is it, lordship?
15th of June.
15th. Alia.
Obliged, lordship.
59 again, contempt.
Yes, sir. Lordship, this contempt application was last occasion Mr. P.K. Bora appeared. So this 22/1/26 was asked to file a
P.K.
complaint.
Bora has left because something has happened, he said.
Yes, madam.
Next week.
Next week, anything, madam.
Mr. B. Kaushik, learned counsel appearing on behalf of Mr. P.K. Bora submits that due to some emergency, Mr. P.K. Bora had to leave the court and has prayed for some time. Prayer is allowed. List this matter on 8th of June.
Grateful, madam.
Deeply
In this method, some accommodation is
last
required,
method,
madam.
kind of
Inspection is not received, madam. So, madam,
Last paragraph of the order, 7/5/26, madam.
some time may be granted.
Several time were granted, my lord, and because of that, my lord, the last order was passed. Last paragraph.
At least 2 weeks time may be granted.
Violation of 6/4/23 order.
Madam. And last paragraph, considering the submission made by so-and-so, for the respondent 1 and 3 courts hesitantly grant further 2 weeks time to file 2 weeks time, the respondent to come with his compliance report by filing an appropriate affidavit, failing which the court will have to direct the personal appearance of the hearing official.
So I'll have to call for the personal.
My lord, here actually what happened, my lord, petitioner was appointed without any advertisement, my lord.
No, don't go into the merits. First of all, answer why have you not filed the affidavit? Otherwise, I'll have to call the officials.
A court pass an order for
Madam,
producing the
this 10
complaint.
days time may be granted so
No.
that we can file our.
Not 10 days. I'll give you 3-4 days.
Now, my lord, prior,
Otherwise, we'll have to call the officials.
my lord, prior to 7/5, similar order was passed by.
Let my lord, may come and fix, Friday, my lord.
Okay, Friday.
So that I can file our affidavit.
Mr. U. Sharma, Learned Counsel submits that although he was supposed to file his affidavit by today, 25/5, today is 25.
Yes, my lord.
Today, but somehow he couldn't file the affidavit.
Compliance report by filing an affidavit.
File the affidavit showing the compliance report. Full stop. It is seen that by the last order, it was directed that if the compliance report was not filed, or if the compliance report was not submitted by way of an affidavit, on the next date, personal appearance of the erring officials should be called for. However, when the matter is taken up today, Mr. U. Sharma praised that for some genuine reasons he could not file the affidavit incorporating the compliance report, and as such praised for 2 days' time for filing the same. For the ends of justice, the time is allowed. Place this matter on 29th of May, by which Mr. Sharma would file the affidavit.
Right.
Or place the compliance report. 61. Yes. What happened here?
Madam, I have filed an IA for amending my prayer, madam. Additional
For?
prayer. For amendment of my prayer in the writ petition.
Amendment of the prayer.
Yes.
Amendment of the prayer by way of an IA.
But it is required by the.
Why don't you file an amended writ petition? That would be better. By IA, how can you pray? I remember an old decision where it is said by affidavits, you cannot. This is interlocutory application.
But now this subsequently a notification is there, my lord. The every prayer has to be in IA, my lord.
Every prayer?
Has to be in the form of IA, my lord.
Any subsequent prayer?
Yes.
No, Lordship.
No,
Now
he
they,
can
he
amend
has
when-
filed an IA for
Amendment.
amending his prayer in the writ petition. Once it is allowed,
Oh,
Lordship,
that prayer does not exist, not
No,
required.
It is exist, it's additional prayer.
additional prayer, Lordship.
So this is not amending, this is additional prayer.
Additional
Lord.
prayer, yes.
So,
my
Lordship,
lord,
perhaps,
my
Lordship, you will have to
lord-
file a fresh writ petition.
No, no, no. My
Or an amended writ petition.
Amend it once
no,
it is
additional
allowed
prayer,
only
my lord.
after that.
Actually, my lord,
Any judgment to bank on.
yes, my lord.
Additional prayer by way of an interlocutory application.
Actually, my lord, May 7. Actually, my lord, the larger issue is pending in division
Division
bench. And in the same, I am filing the IA because, my lord, subsequently recent judgment of the Honorable Apex Court, when applying the doctrine of indirect discrimination in these PWD cases. Indirect.
Your main issue is lying before the division bench.
Yes, Lordship.
Yes, is special.
And then what happened? Why single bench? Take it
But
there.
there are so many cases, series of cases are pending. Because, well, also in the selection process, the entire selection process is complete. Appointment order has been issued. After completion of the selection process, merit list was here, then they go to the reassessment of the percentage of disability, madam. And in the reassessment, they got that their percentage is below the 40%, madam.
So
Therefore,
not eligible for PWD.
no, eligible. That the law is now completely clear, my lord. Actually, the reservation, my lord, in the employment quota, reservation of the quota for PWD. In the PWD Act, there are three category of PWD. One is PWD, one is PWBD, benchmark, and another is PWD having high support need, my lord. There are
Having
high support need.
high support.
High support need. So three category of PWD are there in the act, in the scheme of the act, madam. What happened? Now the state government, what does it? They will give the reservation for PWBD only. Whereas
benchmark.
Only benchmark. But there are three category of PWD. There are the purpose, there are the reasonable, the PWBD and PWD having high support need. The reasonable differential.
See, PW
high support need, my lord.
supporting
Need.
high support need.
Those persons who having the certificate issued by the certifying authority, if there is a scheme framed by the state government, they apply for high support need. In high support need means in the scheme of high support need, there may be employment itself, my lord. There may be employment or other, whatever he needs, his needs. Now another is benchmark disability. Benchmark disability, the concept of benchmark disability has been introduced in the act because they have given 4% reservation in the vacancy, not post vacancy. The total advertisement vacancy, government has to appoint 4% PWBD candidate. 4%. Now then the PWD remains. They are right, not limited to the 4%. They are because they have to a PWD or PWBD, whatever may be, if appeared in the selection. The earlier law is that a PWD has to secure the marks to which category he belongs. Because I belongs to the SC category. I am PWD. I have to secure in the recruitment process the cutoff of the SC candidate. Now the law has been.
You can revert, you can transfer.
Yes,
even to general category.
Yes, I have to adjust in my SC category. Now the Supreme Court law has been cleared that no, the OM has been my lord, the central government issued an OM. The policy has been changed now. Now there is the 4% because it is the statutory obligation of the appropriate government to give not less than 4%. They have to appoint 4% PWBD. What happened? They have given the reservation of the 4%. In the merit list, the last of the candidate of the merit list, then start the PWD 4%. They relax the rule, my lord, the standard, relax the standard. But here is the case, my lord, they have not given any relaxation in the standard, my lord. Everyone got selected by securing marks according to their category. Who belongs to the SC, who belongs to ST, who belongs to the middle. They have given nothing here. Approved government has nothing has given to these people. But after they get selection, the PWBD candidate, they not get the 4%. They only selected 3% or enter in.
So now what is your additional prayer?
Now, my lord, the other candidates, they have been got appointment and joined in their service in 2023. But though my appointment has been issued, but my appointment was held, I was not allowed to join the appointment. Now my prayer, after clear in the law, my lord, by Supreme Court,
Now you have some hope. So
additional prayer, because I have, if I am not given the seniority along with that, my other
incumbent.
then I will lose my seniority and other benefits also. Why? It is not my fault.
Now additional prayer is only because of Supreme Court judgment.
May I interrupt?
But you are objecting to this IA.
Yes, Lordship, because Lordship, in the writ appeal also, he has filed a IA for amendment and addition of prayer.
Because he got that law point after.
Yes, but the Honorable Division Bench has not entertained that IA, and the matter is fixed on 24/6. So Lordship, let this matter come up after 24th of June.
Let's see what division bench does.
Lordship,
Or my lord, a similar prayer has been, I have prayed in the division bench also, my lord, and the issue is same. Or this disposition may be taken with the, my lord.
Not that, we will follow the order by the honorable.
In additional prayer, I only seek, my lord, the declaration that the recruitment rules violates Article 14, 16 and 20 to 21.
Okay, today we will not say anything as prayed for by the learned counsel for the parties. Let's this matter one, Supreme Court.
That is on 24th of 6th, so first week of August, few matters are fixed, Lordship. Similar.
August?
Yes.
Baapre.
Then Lordship, in the first week of July also it can be.
Let's this matter on 28th of July, 20. By that time, Supreme, when is the division bench matter fixed?
24/6.
24/6. So
Yes.
this June.
Yes, June.
So we will take it
20th of July.
after the vacation, 20th of July.
After disposal of the writ appeal, 37/2026.
Okay,
Because it will not.
Otherwise, Lordship, yes. After
It
the
will take
disposal
time,
of
my
the
lord.
writ appeal also.
That day you place it,
Yes.
we will know.
Yes.
Yes.
Highly authorized.
Over. Baapre. Okay. Chalo.